Infractuous. I have instruction to withdraw this case.
Item 47 at the request of Mr.
R. Karim, my lord.
R. Karim, the counsel to the petitioner, who submits that the order has been complied with. Order passed in the writ petition number so and so has been complied with, and therefore
My lord, in fact,
contempt petition may be contempt petition.
My lord, in fact, it has become infractuous, my lord.
How can a contempt become infractuous? Either it is complied or not complied.
Subsequent developments were there.
Submits that because of subsequent developments, he does not wish to press the contempt petition.
but I'm appearing for respondent one, my lord.
Accordingly, the contempt petition stands closed. Mr. S.K. Talukdar appears for respondent number 1.
Oblige, your lord.
Yes.
Made it, my lord, with the consent of the other petitioners and the opposite party, I beg to mention item number 42, 43, 44, and 59, my lord. Supplementary list.
42,
43 and 44, main list, and 59 supplementary list. Take note of all. Kindly taken up this matter on Wednesday, my lord.
we can, once it is fixed, you don't want to do it, it goes.
And the senior counsel, Mr. P.K. Roy, so they have some medical emergency, my lord.
That is all right. So not on Wednesday, we'll post it after 1 week. Item 42, 43,
44 and
Yeah.
59.
there is no 43. 43 as is.
Yes.
Lordship, I appear in item number 43, your lordship.
But 43, there is no item shown in 43. No?
43.
No, no, blank.
Rana side.
Rana Saidu Roman.
Sorry, in my cause list, it is blank. Anyway, item 42, 43, 44,
And 59.
and 59. Be adjourned for 1 week. As it is submitted, the arguing counsel, Mr. P.K. Roy Chaudhary, is indisposed. You are appearing in
43, your lordship.
43. Mr. Roy Chaudhary is not here.
No, my lord. Cancel it.
Okay, in item 43, Mr. K. N. Chaudhary. Since the matters are connected, let these matters be listed after we.
Your lordship, there's an interim order in item 43. Your
Interim order passed earlier will continue.
GP.
Obliged.
With the consent of the other side on behalf of the petitioner, in item number 46, today's daily list. But learned senior counsel, Mr. S.K. Singh is unable to attend today. Can it be on 10th of June?
You are making a prayer on behalf of the applicant.
On behalf of the applicant, the petitioner.
All right. Item 46, be adjourned. To be listed after 2 weeks, you make a mention and fix a date accordingly.
Can it be fixed now? 10th?
10th of June. We don't know what matters are fixed because this is a new roster. So we don't know what matters are
Or it
fixed.
may be
Huh?
after 2 weeks.
Be listed after 2 weeks.
Lovely.
So you may, if it is not listed, then you make a mention on a date to be fixed by the registry.
Good.
Yes.
With the consent of other side, I beg to mention item number 28. madam. I'm for the petitioner. I seek adjournment for 28.
28 at the request of learned counsel for the petitioner, matter stands adjourned for 2 weeks.
Much obliged.
Make it a lordship. Sorry, my lord, item 13, lordship, motion matter, lordship. I pray for the day, lordship, only I have some personal difficulty, lordship.
Item 13 be listed next week at the request of learned counsel for the petitioner. Next week?
This week, if possible, lordship, on 13, sorry, on Wednesday.
No, Wednesday will be difficult. We don't know what matters are fixed. Already on
Next-
Friday,
Next
On-
Monday, lordship, I will be out of.
on
station.
Monday, okay. On Monday would be 27th. List on 27th.
May please, your lordship. Lordship, I beg to mention item number 1, lordship. On behalf of Mr. P. Ahmed, my lord, he is suffering from illness, my lord. The matter will come on next week, my lord.
Item 1.
1.
Item 1 be adjourned for 2 weeks, as it is submitted that counsel for the petitioner is indisposed. Mention is made by Mr.
F. A. Hassan.
F. A. Hassan. Have you taken consent of the other side?
I'm a prayer. Yes.
No objection. Government council does not object to the prayer made. List accordingly. Yes.
Please, your lordship, I beg to mention item number 50, your lordship. Your lordship, respondent number 3, that is the revenue department has filed its affidavit in opposition in IA. Your lordship may kindly grant us 2 weeks time to file affidavit in reply.
Item 50 be adjourned for 2 weeks, enabling the petitioner applicant to file reply affidavit to the affidavit filed by the Revenue Department. Yes.
Well, I prefer listing of a writ petition for admission, my lord. This is last listed on 21/12/2023, my lord. Next week, my lord, Monday.
Next week.
Monday, if possible, my lord.
On 5th of June,
Before that, 29th.
before that 29th, we don't know. 31st,
Hello, bless.
it's on 31st.
May it please your lordship. Lordship, I beg to mention item number 32. Lordship, I'm for the petitioner. Lordship, in this case, there are some new development which may render the case to be infructuous. And therefore, we need some time.
32.
Yes,
Item 32, it is submitted on behalf of the
petitioner.
writ petitioner that matter be taken up after 2 weeks, enabling the counsel for the petitioner to complete the instructions as to whether the writ petitioner is to be pursued any further or not. Yes.
May I please, your lordship? Lordship, I am paying for listing on with petition. It was last posted on 1 December 2020.
What is the subject matter?
Lordship, that I
You get your instructions, mention it. Find out what is the subject matter. What matter? Why is it not been listed? You approach the registry, file an application. It will be listed before the appropriate bench. Okay?
May it please, I beg to mention for listing of writ petition, lordship. It was filed on Friday for tomorrow, lordship. There is no-
What is the matter?
Lordship, petitioner's land, Patta land is in the vicinity of Margata railway station, lordship. And the railway authority, the petitioner has an apprehension that railway authority may encroach the petitioner's land because they are extending the platform.
Let it be on Wednesday.
Yes. Public.
Yes.
May it please your lordship. Lordship, I beg to mention for item number 9. Lordship, kindly pass over for the date. The learned counsel is out of station, lordship.
Who is the counsel?
Lordship, R.S. Misra.
It is, a mention is made on behalf of Mr. R.S. Misra that the counsel is out of station and therefore the matter be passed over. Okay. Accordingly, let the matter be listed next week on a date to be fixed by the registry. Yes.
Obliged. May it please your lordship. I beg to mention orders item 52. As the senior counsel is out of station, matter may be adjourned for the day, my lord.
52.
52.
At the request of learned counsel for the petitioner, matter stands adjourned for the week.
My lord, to be come up on Wednesday.
Let it be next week.
Obliged.
May it please your lordship. Lordship, I'd like to mention item number 25 and 26 for adjournment, lordship. My senior has some difficulty today.
25,
And 26.
25, 26 at the request of learned counsel for the respondent.
In one case, we are the petitioner, and in the other,
On behalf of Mr. K.K. Mahanto, senior counsel, matter stands adjourned for 1 week.
lordship, could a date be fixed in this matter?
What is the point?
Lordship, this is with regard to cutting off a hill, lordship. We are seeking implementation of certain orders of the DC.
See, it is listed today. You are not convenient.
Lordship, maybe after a week, lordship.
After a week, you give us a date.
Lordship, any date after a week,
7th of June.
lordship. Much obliged.
May I please, Lord?
Yes.
Well, I mean, permitted no urgent application. 3 numbers of RCC buildings are under demolition, Lordship, from 10th of last month, Lordship. So I mean.
By whom?
I filed it by a private individual, Lord, without having any order, any degree.
You have filed a writ petition.
Yes.
When?
It went yesterday, WPC number 1565.
Let it be listed on Wednesday.
Lordship, demolition. No, sorry, we filed on 17th of May. Today also demolition is going on with the electric hammer.
Let it be tomorrow then.
Obliged.
Tomorrow.
It's non-compliance of the order, my lord, started at base 11, my lord, of 40.
Operative part below is 16, my lord. Matter relating to ex gratia compensation.
Yes.
My lord.
What is the direction?
Direction, my lord, started from page 15, paragraph 10, my lord. Bottom, my lord. Directed to make inquiry and pay ex gratia if entitled, my lord. This is the direction. In terms of the notification, my lord, 15/11/2014.
Then what happened?
Then, my lord, the petitioner communicated the order, my lord, to the respondent, but they have not taken any action till date.
We had learned counsel for the petitioner being aggrieved by non-compliance, by deliberate and willful non-compliance of the directions contained in the order dated 27/3/2023 passed in WPC 7562 of 2022. The petitioners before this court filing the contempt petition. Issue notice, returnable 4 weeks. Steps on respondents by registered post and usual post within 1 week from the date. How many respondents?
2 respondents.
3.
Or 3, my lord.
No. Yes,
3, 4, 5 are similar, my lord.
similar order, 3, 4, 5.
The date and writ petition number are different.
Same writ petition,
No, my lord.
different writ petition.
Different.
Okay.
Of my lord. 3,
Writ
4,
petition or order get aside. Yes.
Yes, Lordship. In this matter, your Lordship, the
We received after some time at 2 p.m. Lordship. They have left from the Boca. I have been told,
10:15 was the time,
but
specifically in the
yes,
order.
because I have
And the government advocate was directed to inform. After that, why 2 p.m.?
because I have talked with them. They have left already from the Boca.
No, they are not obliging the court by leaving at
That is
10
true.
o'clock.
That is true.
There is an order of the court
I
at
lift your lordship.
10:15. Why
But
is it, as whose fault the officer is not before the court at 10:15?
No, already we have sent our letters, Lordship. We have already sent our letters, Lordship. And I have been informed they will receive after some time. Lord.
Have you seen the order?
I have seen, Lord.
There is a time
Yes, yes, sir.
mentioned in the order.
Yes, yes. Lordship.
Then why is he not here at 10:15? What do you mean he is left from Daboka? He knows what time
Yes,
if he has seen this order,
Lordship.
he knows at what time the
Lordship.
court has asked for the CD.
Lordship.
Why is he not left? Why is he not before the court?
I lift your Lordship.
Huh? Have you communicated the order?
Lordship. Yes, Lord.
When did you communicate and to whom and how?
For email, Lordship, to the SP and the officer in charge, Lordship.
Do they have emails?
Lordship.
Do they have emails?
To SP they have, SP Huzai.
Okay, you inform the SP and inform the SP that the court's order has not been complied with. Find out what time is he coming. Bring it before the court immediately. Today,
SP.
you inform the SP
Lordship.
that his officer in charge is not before the court in terms of the order. What has happened to the officer in charge along with the CD? Find out and inform us.
Lordship. And I have been told he's already coming on the way to his court, Lordship.
Please get him before the court.
Lordship. Lordship.
May I please, your Lordship?
Lordship, matter pertinent to ex gratia, your Lordship. Here, Lordship, on last occasion, Honorable Court issued notice to the respondent authority and directed to file an additional affidavit, your Lordship, whether we have claim under the railway tribunal or not. And accordingly, your Lordship, we have filed an additional affidavit elaborating the claim of the railway tribunal, your Lordship, which was filed on 10 of May, your Lordship. If your Lordship will find in our additional affidavit at page 38, your Lordship, the order that is decided by the railway tribunal awarded compensation of an amount of rupees 8 lakh, your Lordship. And
Who's for the railway?
Railway not appearing.
Right?
So this is,
Not
he is
against the,
claiming under the ex gratia scheme under Government of Assam, Revenue Department.
railway is also there.
yes, Lordship, we have made file.
Have you taken steps on the railway?
Yes, Lordship.
Yes.
He
what
has
you-
additionally received ex gratia and the compensation from the railway tribunal. That is a fact, madam. And we have written to the department whether he is still eligible to get the compensation under the ex gratia scheme. So we are awaiting that instruction, and Lordship may kindly grant us some time so that we can have that
You are appearing for
revenue department.
Mr. A. Bhattacharya, learned counsel, appearing for the revenue department.
Respond number 1.
Further time to complete his instructions in respect of the ex gratia required to be paid to the direct petitioner. Mr.
Yes, sir.
S.
Yeah, can.
S.I. Akand appears for the direct petitioner. Mr. Nayak for the finance department. Let the matter be listed after 2 weeks, enabling the respondents to complete their instructions and apprise the court in respect of the claims made by the writ petitioner.
I'm deeply obliged.
Yes.
Please, your Lordship. Well, my land has been occupied by a school, school authority. And I have approached the authorities, they say they don't have the building permission and all. My lord, the deputy commissioner also asked the concerned department to take action. The GMC, GMD went to the place, the school authorities did not allow him to enter. They sought for police help. Nothing is coming out of it. So today I only pray, my lord, that the notices go. In the meantime, my lord.
How have you approached the GMC authorities?
Well, at page 32 is the first RTI information they have given.
No,
It's
but
start from page 30.
have you filed any?
Yes, I have filed a representation also. I have annexed that matter. At page 108, 1062, 1029 are the representation. First is at 106.
All right. Yes, Mr. Nayak,
Lots of I'll take instruction.
heard learned counsel for the parties issue notice. Returnable 4 weeks. Mr. E. Nayak appears for all respondents.
1 to 5 lots.
1 to 5. Then steps by usual course and registered AD on respondent 6 and 7 to be taken within 1 week from today. Let the matter be listed after the returnable date.
It may pay on 25th of June.
Since Mr. Nayak has already entered appearances,
26.
extra copies, notices are waived, but extra copies will be published within the course of the day.
26 June.
Oh, we can't give you 26 June.
After 4 weeks, any day. Just a fixed day, madam. Just. Let them complete the formality. I don't think that anything will happen on the next day.
Like 26 June.
May please, your Lordship. My lord, the prisoner is the owner of the land, my lord. And it was in the name of her son. Thereafter, she submitted application for demarcation of the land matter. Though some communication is there, madam, there is no final outcome, madam, till date. We have approached the deputy commissioner, madam, and finally submitted representation also, madam.
Get your instructions, Mr.
Well, it's a notified service. Therefore, he has to apply under that provision of the that notification before the circle officer in proper format, madam. If he has not annexed that document, madam, I cannot say.
Madam, there is some communication, madam.
No, the communication all right, but he has
Have
to,
you applied
yeah, he
Yes,
has
madam.
to apply it in
as per the
standard form.
procedure prescribed?
Madam, though not procedure, but thereafter notice was issued. People also called, my lord. Other people also, hearing also took place, my lord.
You find out on the status of what happened.
The deputy commissioner will say, madam, in that case. madam.
Who's appearing for?
She is appearing.
Take instruction.
Okay, her turn at counsel for the parties. Let the government advocate apprise the court, complete their instructions and apprise the court on the claims made by the writ petitioner. MS
S. Borua.
S. Borua appears for the
Respondent number 2, 3, and 4.
respondents 2, 3, and 4. Mr. A. Bhattacharya for respondent 1.
One.
Let the matter be listed again on after 2 weeks on a date to be fixed by the registry.
Madam, madam, pendency may not be got to consider, madam, because it is pending. Because-
Why?
Yes, my
your-
application is pending.
You have failed to get an order and therefore you are before the court.
All right, sir. Pass over.
May I please your lordship. Here, my lord, the petitioner forefathers or petitioners or the petitioners are riot of the under the Mirajdarment. Therefore, the later on by Zamindari's Act, my lord, the entire land was taken up by the government. Now, the riotee who are holding the land under the Mirajdar. The law is that, my lord, even if the government is taken up the land, if the government acquire the land, even though they are to held the land as a Satyanda under the government, my lord. This is the Assam State Acquisition Zamindari's Act. Section 4, clause 6 of section 4, my lord. So only the record of right is to be maintained, my lord. We don't have any other claim. We don't have any other claim, only to record our name as the legal heirs, so that we will continue to hold the land as a riotee, my lord. There is clause 6, my lord. Clause 6 here.
Yes. Please read.
No, I don't have the copy, there is the book.
Oh.
So even if the land is taken by the government under Zamindari's Act, they are still continue with the as a tenant under the government. Only that record is to be maintained.
As on date, your names are not.
No, because our forefathers' names are there. Petitioners' names are there.
Yes.
Notice have to go, lordship. They have applied in Bosumara.
Weeks. MSS.
Documents are developed.
appears for respondent number 2, 3, Mr. A. Bhattacharya for respondent number 1. Let since the standing government advocates appear, notices are waived, however, extra copies be furnished within a period of 1 week. Matter be listed after the returnable date.
Obliged.
Please, your lordship. Lordship, herein actually the challenge is to the freezing of the bank account of the petitioner, your lordship. What has happened, your lordship? Is
What has
that-
happened to the proceedings? There was
Lordship,
some complaint lodged by the husband.
Lordship, there has not been any communication to us subsequent to that, your lordship. We have lost around more than 1.2 crores, your lordship. And
From this account,
Not from this account, your lordship. This is my account. The husband's account also has been freezed, but we've not approached this honorable court with respect to that. This is, I transferred 4,60,000 to the petitioner's account, the husband of the petitioner. And thereafter, your lordship, this account has been freezed, your lordship. And our main.
Let notice go,
Lordship.
let notice be issued. Returnable 4 weeks. And MSS, Polwa, ATS for
1 and 4, Lordship.
respondents, part and 4. Steps on respondent 2 and 3 by registered post 80, along with the usual hold within 1 week from today. Learned counsellor representing respondents 1 and 4 be furnished with sufficient extra copies to obtain her required instructions. Let the matter be listed after 4 weeks. Notice also on the interim rate. Returnable 4 weeks at least. The account is maintained in SBI.
Lordship, notice would also have to go on respondent number 4, your lordship.
We have
Lordship.
directed, take steps.
Much obliged.
Yes.
Similar matters are pending before this court, in which I have furnished a similar order to the bench. Lordship, this matter pertains to a demand under section 16(4). And since the same is pending at Supreme Court, so this matter had come up before this court wherein notices were issued and the order was directed not to be enforced by the authority, Lordship.
For the respondents,
So Mr. Kyal should be there, Lordship.
is informing. Is informing. Follow up after a while. Yes, Mr. Bora.
Yes. My lord, this petitioner is a school, my lord, and the petitioner number 2 and 3 are the president and the secretary of the school. Now we are a registered society, my lord, and there's a dispute between some of the members, my lord. There are 2 factions now. Now they are also claiming, and we have an injunction in our favor, my lord, that is operating. In the meantime, one of the person, he has lodged an FIR, my lord. Lordship will kindly see page 73. That is the FIR against all of us, my lord, regarding falsification and various allegations, obtaining false society registration, etc., 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 my lord. To that effect, my lord, the investigation has started. In the meantime, this FIR also been forwarded to the register of the societies, my lord, page 72, my lord. And the basis of that FIR, now the register has issued this notice to us and also called for the written statement from us, madam. So that will cause the prejudice, my lord. Already the criminal investigation is going on. And there is a bar containing in article.
Is this the FIR treated to be the complaint or some other complaint was
This
filed?
is the FIR.
This is the complaint.
Yes, yes. On the basis of that, he has issued the notice to us and asked for the written statement. And there's a bar, my lord, lordship knows, my lord, article subsection 220 subsection 3, when the investigation is pending, that will cause prejudice, that may cause prejudice to us. So at this stage, only prayer is just to keep in abeyance of this particular notice, my lord.
And what is the status of the civil court?
Civil court injunction is our favor, my lord.
Injunction in respect of?
That they are trying to show that they are the secretary and president, my lord, the other group. Now that has been stayed by, and the injunction is our favor. Thereafter, this FIR has been lodged. There is a defalcation of money, the falsification of the account, lots of account. Then, on the basis of that FIR itself, this notice has been issued to us by the registrar itself, and he himself said, my lord, on the basis of that complaint, my lord.
No, that's what we are trying to understand.
Yes, yes.
Is there
From
a
the-
separate complaint or?
No,
is
no,
the
no, they're the same complaint, my lord.
FIR is treated to be the complaint.
Yes, yes. It is, my lord, the complaint petition submitted by Mr. Tridip Kumar. Page 72, my lord, and lordship will find the FIR. This is filed by the Tridip Kumar. Page 76, last part, Tridip Kumar.
Anyone for the respondents? Heard. Mr. A.M. Bora, that's the counsel, assisted by Mr.
V.A. Chaudhary.
V.A. Chaudhary. This writ petition is filed by the petitioner. Aggrieved by the notice dated 30 April 2024, issued by the Registrar of Firms and Societies. So the notice is issued to the petitioner number 3 in his capacity as the secretary of Tinsukia English Academy Society. Learned senior counsel appearing for the petition submits that the petitioner number 1 society runs an English medium school in which the petitioner number 2 and 3 are president and secretary respectively. The private respondent number 3 is a member of the said society, and certain disputes had arisen between the present office bearers and some other members of the society. In this connection, a civil suit is also pending, whereby the court of, where is the injunction order?
My lord, page 70, 60, 67 onwards, my lord.
Whereby the court of civil judge within bracket senior division Tinsukia in Miss J case number 47 of 2024 arising out of Miss Appeal number 02/2024 granted an injunction, and the matter is presently pending before the state court. Stop. Meanwhile, private respondent number 3 had filed an FIR before the officer in charge in India police station dated 11/2/2024, where these several persons are arrayed as accused persons, including the petitioner 2 and 3. Petitioner 2 and 3 are also
Yes, yes.
named as accused.
Yes.
So it is the submission of the learned senior counsel that the Registrar of Firms and Societies by the said imbued notice dated 30 April 2024, on the basis of the FIR, a copy of which was sent to the trade office, had issued the impugned notice to the petition number 3, directing them to file written statement in respect of the complaint submitted by the informant, namely respondent. Learned counsel, senior counsel submit that the matter is already submitted before the civil court, and there is an injunction operating in their favor. Stop that apart. The pursuant to the FIR being lodged, the police is undertaking the investigation. Under such circumstances, if the petitioners are compelled to appear before the Registrar of Firms and Societies and file their response, they are likely to be gravely prejudiced. He therefore submits the appropriate order be passed by the school. Anyone for respondents?
I've got two lots.
Government advocate appears for respondent number 1 and 2.
Oh, no, I'm for two lots. There is standing counsel for one lot.
Who is this standing counsel? Appears for 1 and 2. Who submits that he does not have any instruction. Do you have any instructions here?
No.
Therefore, submits that he be permitted to obtain instruction. Accordingly, let notice be issued within about 4 weeks. Since the government advocate has entered appearance on behalf of 1 and 2, notices are waived. However, extra copies be furnished within a period of 1 week from today. Steps on respondent 3 by registered will take up with this full force within 1 week. Meanwhile, in the next returnable date, the further proceedings till the next returnable date, the impugned notice dated so and so. And all further proceedings thereto shall remain stayed. Matter be listed again on 7/2.
Problem.
Thank you.
May I please your lordship? Lordship, I am appearing on behalf of my senior Abhivati. He's on his leg in another court. Matter may be passed over for the timing.
Let me go. Okay, the respondent is a government enterprise, and they've floated several tenders for construction of Ekalaba Model International School all across India. Okay? The petitioner participated in 2 of those tenders. And thereafter, even though he participated and submitted all the documents online, thereafter he was repeatedly being asked to submit further documents, additional documents. And even though he was a little bit surprised because after submission of online documents, it is generally not permissible to furnish further or additional documents, he kept on abiding the request of the respondent. Thereafter, there was a rumor spread all over India that this enterprise, they are floating the tenders and they are not going to allot any work order to anyone. And ultimately, there was also a subsequent rumor that the security deposit of all the contractors, bidders will be forfeited. In fact, I can show later on the rumor went on to be a fact and true fact. And all the contractors, the security deposit mostly were forfeited and they were blacklisted. Petitioner is also one of the victims of that thing, Your Lordship. So I am alleging malafide intention of the respondent, Your Lordship. And subsequently, what happened when the petitioner came to know, he earlier requested for release of the forfeited, the security deposit. As soon as he requested for the release of the security deposit, the respondent authority issued a show cause notice alleging that he had submitted false document during the participation of online bidding, Your Lordship. That show cause notice is at page 33, Your Lordship.
Yeah.
This is the show cause notice, Your Lordship. The relevant portion is page 34. On verification, it has been confirmed that the client means National Health Mission, that the completion certificate have not been issued by their office. This is the allegation. And after receiving the show cause notice, I gave a reply, which is at page 35.
Yes.
I have explained that these completion certificates are generally issued by the engineer of the concerned department, and these are not from the office file. This is only for the purpose of participation in tender, Your Lordship. And then at the penultimate paragraph, Your Lordship, the last sentence, I also request for a hearing if this reply is not found satisfactory. So this is my right, Your Lordship. But without giving the matter remain pending like that. And by way of this reply, I also requested them to release the security deposit. They neither release the security deposit, nor call me for any hearing. As the matter remained pending like this, it was in the month of January 2022. Thereafter, I started participating in other tenders. And subsequently, while executing work in another tender under Assam Police Housing Corporation Limited, I got a letter of show cause notice again, now this time from Assam Police Housing Corporation Limited, alleging that I have falsely stated that I was never debarred from any company, any department. And along with the letter, an annexure was given, from which I came to know that I have been earlier debarred by the respondent hearing from participating in, and I was blacklisted. That blacklisted order is your lordship at page 38. The relevant portion is page 39. MS Nipul Kulta, the petitioner, is disqualified from evaluation process in the said tender, and the bid that so and so submitted against the said tender and rejected. The security deposit so and so submitted by is forfeited. The competent authority of TCIL, that is respondent, has imposed a ban on petitioner as per clause so and so under reference for a period of 5 years from the date of issue of banning order, that is 29/3/2022. I was banned in March 2022 and I was not aware because this document was never communicated to me.
When did you apply for the tender in question?
This
where your security deposit?
Yes, on 18/2/2021, I participated in 2 tender processes. The SOCOS notice was issued on 15/12/2021.
And when were you banned?
I was banned in 2022, your lordship, 24 March. But I was not aware. I came to know last month only, when another department, a state department, issued a SOCOS notice to me. And even though I gave a reply, they also banned me. Now, my only concern, I am apprehending your lordship, that this prima facie, this debarment notice itself is illegal. But on the basis of this debarment notice, I will be again debarred from participating in other tender contract works, which I am presently pursuing, your lordship. That is my apprehension. So at this stage, I am praying that this debarment notice may be stayed, your lordship, the impugn debarment notice, and notice may be issued, your lordship. Because if this is not stayed, then all the other departments under whom I am performing my contract work, they will start debarring me.
No, but this was issued in 22.
22. I came to know last month, your lord.
Maybe last month, but what will be the effect of staying this notification? Because
at least wherever I have participated in other contract work, at least 10 to 12 presently I am doing contract work, your lordship.
Whatever, as and when you face difficulty, you come before the court.
I have already faced, your lordship. As an instance, I am showing your lordship at page 36. I am already debarred. Recently, your lordship, page 36. And this is, I am not the only victim. This has been done to all the participants. I have annexed all the debarment notice. Randomly, they debarred all the contractors. Page 36, your lordship. This is dated 24/4/2024.
Heard Mr. P.K. Sharma, learned counsel appearing to the writ. Its petitioner is before this court. So essentially, you have 2 prayers.
One for release of the security deposit and other for cancellation.
Before this court for seeking an order for release of the security deposits. In respect of which contract?
Yes, your lordship. The name of your lordship will find it at page 33, annexure 5.
In respect of which these tender numbers 1, 2, and 3. Sorry, 1 and 2.
1 and 2, yes, your lordship.
Tender numbers 1 and 2, huh? Page number 33. Whereby the petitioner participated in the tender process. However, the security deposit of the petitioner has, in these tenders, have been cancelled.
This tender has cancelled, yes.
Whereby
It was cancelled.
the respondent authority had cancelled this tender so far as the petitioner is concerned. However, the security deposit has not been released. So, subsequent, the petitioner, while undertaking contracts with other authorities, came to be aware that by an order dated
24/3/2022, page 38.
24/3/2023, 2022, annexure 8, page 38 of the writ petition. The petitioner was banned by the authority from doing any business across TCIL for all items, works, or services. Stop this the petitioner is banned or debarred from participation in TCIL tenders / EOI for a period of 5 years from the date of issue of this order. The learned counsel for the petitioner submits that because of his banning and debarring order, which was issued behind his back, and which order he came to be aware of only recently, the petitioner apprehends that there will be other areas, there will be other contracts where he has participated and is presently executing the same. There is a likelihood that the state authorities may also cancel his contract on the basis of the order, ban or debarring order passed by the respondent authorities. So it is submitted that his debarring or ban order would not have been issued against him without putting him to notice, giving him an opportunity to
Opportunity of hearing your
an opportunity of being heard. Stop that. Under such circumstances, the petitioner for this court for appropriate redaction. Right? Accordingly, let notice be issued returnable 4 weeks. The sole respondent is the Government of India undertaking and is not represented by the council. Therefore, steps on the sole respondent be undertaken by usual course or registered post within 1 week from today. Let notice also be issued on the prayer for interim. We'll consider your interim prayer after you serve notice.
In the meantime, it may be stayed, your lordship. Because I've hurriedly filed this petition because I apprehend I am already doing 3 works under PWD, your lord. Only stay for the next till next day, your lord.
The order dated so and so passed by the till the next date fix. The order dated so and so. No, but you are expressing apprehension against whom? That you have to state in the petition.
I have stated
how many
that
contracts?
I've done several.
You have not arranged them as parties also.
No, your lordship, since I have been doing contracts and I have already participated in general, your lordship, I am apprehending because one instance I have shown that last month only I have been banned on the basis of.
Till the next returnable date, the impugned order dated so and so shall not be given effect. Is the matter on 7th June?
Highly obliged, your lordship.
4 weeks old. 7 more. Inform for the 21st. 4 weeks. Yes, sir.
The petitioner was a registered dealer under Assam VAT Act and CST Act at the relevant time made sales of pan masala to a dealer in Gujarat. Now the dealer in Gujarat was also a registered dealer. Now the goods were dispatched to the dealer at Gujarat along with all documents and papers, the necessary e-way, the necessary road permit, the transporters, the receipts, bills, all payments were also received through bank, and a C form was received by the petitioner from the Gujarat dealer. Now at that time, the C form was to be generated online, and the online registered, the generated C form was also received by the petitioner. Subsequently, the petitioner received a notice, which will also find at page 32, my lord. You also find 32, this was a notice issued by the Assistant Commissioner of Taxes. Whereas from the information available, it has come to the notice, the receipt form number so-and-so, which you have received from so-and-so, or an amount of rupees so-and-so during the period from 1/1/16 to 31/3/16 has been declared obsolete by the concerned authority. As such, you are hereby asked to deposit the balance amount against transactions mentioned in C form, which were declared obsolete by the Haryana government. Now, you'll also kindly see the affidavit of position. Regulation, the link page government.
Yes.
Page 8, my lord. You also got it.
Yes.
My lord. This is a letter from the Deputy Commissioner of Taxes to the Assistant Commissioner of Taxes. Enclosed, please find herewith a copy of the email dated 19/2/2018 received from the Excise and Taxation Officer and Assessing Officer Gurgaon, which speaks for itself, and are requested to take necessary action on the dealer so-and-so as per the provisions of the Act. Action taken in this regard may be requested, intimated to this office in due course. Now, the communication received is on page 9, my lord.
Yes.
Hello, sir. Respectfully, it is brought to your notice that some unknown person fraudulently has obtained the C form from this office, showing purchaser as so-and-so. In this transaction, the seller from Assam, the said forms have been obtained for the period from so-and-so. The details of the dealers of your state PIN number and so-and-so received by the dealer is as formed. As per the Haryana dealer, my lordship, as per the Haryana dealer had neither made any purchases nor involved in the said transaction. In this circumstance, the C form issued to Om Trading Gurgaon has been cancelled, and the department is in the process of declaring the form as obsolete. So, my lord, it was mentioned that my lord, the said C form was cancelled, and the department was in the process of declaring the form to be obsolete. Therefore, you are requested to direct concerned authorities of those who are not to give the benefit of the concessional rate of sales to dealer of your state, as no purchases have been made by the Haryana dealer, and C form issued to the dealer have been cancelled. Now, my lord, three things emerges from the said corresponding from the assessing officer to Gurgaon. My lord, here one thing is said that the C form was, my lord, the sense of fraudulently obtained C form from this office. My lord, the C forms at that time was never obtained from the office. It was in online, which has to be generated by the purchaser, and the online generated C form was issued to the petitioner.
No, who is the author of this letter?
My lord,
Who has written this letter?
my lord, this is Gurgaon Haryana authority, my lord. The first, my lord,
You had purchased from Om Traders.
I sold, my lord.
You sold
My lord.
Om Traders.
Om Traders.
And who is the other Haryana dealer, or it is Om Traders only?
Om Traders, my lord.
Okay.
Om Traders. And he issued me a C form generated online. So there is no question of some unknown person fraudulently obtained C form from the office. Physical C form was not there, my lord. The dealer has to generate the C form online. Secondly, my lord, you also find it says, as the Haryana dealer had neither made any purchases nor involved in the said transaction. You know, how the authority can say that the Haryana dealer has not made any purchases nor made, because I have all the documents that the payments were also received from the said dealer from the bank.
And all the transactions, the transportation, the receipt of the goods, they are all available. I have annexed everything. Thirdly, my lord, it said that they have cancelled the C form and are in the process of declaring the C form to be obsolete. Now, the notice you also will see page 32. It says that saved C form has been declared to be obsolete.
Page number
Page 32, my lord.
of the writ petition.
My lord.
Yes.
It says, my lord, so-and-so amount of so-and-so during the period so-and-so has been declared obsolete by the concerned issuing authority. Whereas the communication says that it has been cancelled and they are in the process of declaring the form to be obsolete. Now, my lord, there is no power under the CST Act to cancel any C form. Secondly, my lord, even if a form is declared to be obsolete, it cannot be given a retrospective effect. If at the time when the purchases were made, the sales were made, the C form was valid and the C form was issued, subsequent declaration of the obsolete of the C form will not affect the transactions which has taken place in the relevant time. There are judicial precedents on that issue. Now, where in one of the state, my lord, the cancellation power was incorporated in the state rules, the High Court held that the power of cancellation is not there, and thereby that rule, which has been incorporated in the state rules, is ultra vires because that goes against the CST Act and the rules. Thirdly, in this case, no assessment has been made. Only a letter has been issued that you make payment of this tax. As you lordship is aware, that in a taxing below statute and the system, first there must be a charge, then levy, then assessment, and then recovery. Recovery cannot precede the assessment. One cannot ask a dealer to make payment of any tax amount without making any assessment. Now, in this case, no assessment having been made for the period 2015-16, the assessing authority has no power and jurisdiction at all to direct the dealer to make payment of the tax. Now, my lord, the various high courts and the Supreme Court have held, my lord, Supreme Court has held, my lord, that the duty of a dealer whilst making a sale of the goods is to see whether he is a registered dealer or not, whether the item which he purchased is incorporated in the certificate of registration or not. If these inquiries are made, then the purchasing dealer has not duty to make any further inquiries to the effect that whether, unless and until the C form has been declared to be absolute prior to the making of the transaction. If prior to making of the transaction, the C forms were invalid, one can say that, my lord, you cannot take benefit of the said C form. But if the C forms are declared to be obsolete, in this case, from the correspondence, it appears that they are in the process of declaring it to be obsolete. That was in 2018. And we are concerned with the assessment year 2015-16.
Yes.
So that is clear that up to 2016, 31st March 2016, the C forms were not declared to be obsolete by the Department of the Haryana, and they were valid. Once they were valid during the period when the transaction was made, that is 2015-16, even if the same is declared to be obsolete in the year 2018 onwards, with nowhere, my lord, the department has also said it has been declared to be obsolete. They are saying that we are in the process of declaring it to obsolete, meaning thereby up to 2018, when the correspondence was made, the C form was not declared to be obsolete. If it was not declared to be obsolete by that time when the notice was issued, and the C form was valid for the period when the C form was issued, my lord, the retrospective, the subsequent declaration of the absolute, even if they do it, cannot affect the transactions which have already taken place in the earlier years. These are the, my lord, the legal issues which I am raising before Lordship, my lord. I rely on certain decisions, my lord. Ito copy ko di ba? The first decision is of the Supreme Court at page, it starts from page 1 and you'll also can see page 7.
Yes.
You'll also can see page 6, last line.
Yes.
The Act seeks to impose tax on transactions, amongst others, of sale and purchase in interstate trade and commerce. Though the tax under the Act is levied primarily from the seller, the burden is ultimately passed on to the consumer of the goods because it enters into the price paid by them. Parliament, with a view to reduce the burden on the consumer arising out of the multiple taxation, has provided in respect of the sales of declared goods which have special importance in the interstate trade of commerce and other classes of goods which are purchased at intermediate stage in the stream of the trade and commerce, prescribe low rates of taxation when such transactions take place in course of interstate trade and commerce. Indisputably, the seller can have, in these circumstances, transaction no control over the purchaser. He has to rely on the representation made to him. He must satisfy himself that the purchaser is a registered dealer and the goods purchased are specified in the certificate, but his duty extends no further. If he is satisfied that these two matters on a representation made by him in the manner prescribed by the rules and the representation is recorded in the certificate of Form C, the selling dealer is under no further obligation to see to the application of the goods for the purpose for which it was represented that the goods were intended to be used. If the purchasing dealer misapplies the goods, he incurs a penalty under Section 10. That penalty is incurred by the purchasing dealer and cannot be visited upon the selling dealer. The selling dealer under the Act is authorized to collect from the purchasing dealer the amount of tax by him as tax on the transaction, and he can collect that amount only in the light of the declaration mentioned in certificate in the Form C. He cannot hold an inquiry whether the notified authority who issued the certificate of registration acted properly or ascertain whether the purchaser, notwithstanding the declaration, was likely to use the goods for a purpose other than the purpose mentioned in the certificate C. There is nothing in the Act or the rules that the infraction of the law committed by the purchase dealer by misapplication of the goods after he purchased them or by any fraudulent misrepresentation by them, penalty can be visited upon the selling dealer. There is no dispute that the dealer was a registered dealer. There is no dispute that the item was included in the certificate registration. There is no dispute that the C form was generated online by the purchasing dealer and was supplied to me. Now, only the mention that the Haryana dealer has not received the goods. How they know? How the Haryana assessing authority came to know that the Haryana dealer has not received the goods? And side by side, they are saying
There is no assessment for the dealer for that.
But 2018, there was no assessment. If somebody had purchased the goods and thereafter manages, and the assessing authority says that he has not received the goods, how they came to know that he has not received the goods? When all the documents and papers are there that they have received the goods. And the C form was issued by him, not procured from, he said that fraudulently obtained from the office, that is absolutely incorrect. Now, you'll also kindly see me on page 9. You see another Supreme Court decision. And you also kindly see page paragraph 5
Paragraph 5.
at page 10.
Yes.
In our view, the High Court was right. A purchasing dealer is entitled by law to rely on the certificate registration of the selling dealer and act upon it. Whatever may be the direct effect of retrospective cancellation upon the selling dealer, you are also kindly noting, it can have no effect upon any person who has acted upon the strength of the registration certificate, whether the registration was correct. This is about the registration certificate, my lord, that even if the registration certificate is cancelled, my lord, retrospectively, it can have no effect. The argument on behalf of the department that it was the duty of the person dealing with the registered dealer to find out whether a state of facts existed which could justify the cancellation of registration must be rejected. To accept it would be to nullify the provisions of the statute which entitle persons dealing with the registered dealers to act upon the strength of the registration certificate.
Yes.
Now you'll also kindly see at page 27. There's here judgment of the Punjab High Court, my lord. And I will take your lordship to para 13. The last paragraph, 3 or 4 lines.
Yes.
The inaction, neglect, as you also got, my lord.
Yes.
The inaction, neglect, or even fraud of a registered purchasing dealer cannot result in penalizing the innocent selling dealer in the absence of evidence of having been a party to the fraud, deception, or misrepresentation.
Yes.
Now we'll also kindly see, my lord, page 32. This is a decision of the Odisha High Court. And I may take your lordship to para 11, my lord.
Yes.
Lord, before we part with the case, we must bring to the notice of the state the registered dealers is indeed registration of dealers is indeed a serious matter, and the officers authorized to grant registration should be very careful. Once a certificate registration is issued to a person and he becomes a registered dealer, he is entitled to certain benefits under the Act. Certificates granted by the public officers have their value, and people in commercial field would be in normal course accept such certificates to be genuine. The fact that registration has been cancelled, has been granted, yet the person holding the certificate is fictitious, one seems to be contradictions in term. A certificate registration can be granted only when the dealer, apart from being a businessman, satisfies the other requirements prescribed by law. A registration certificate cannot be granted to a non-existent person. The fact that there have been some persons who are labeled by the department as fictitious dealer goes to show that the officers under the Act either collude or with dishonest people in the field or fail to exercise due diligence and allow fraud to be practiced in the commercial field. Whether it was collusion or negligence, these officers being disrepute to the state and introduce uncertainty and lack of confidence into the true field and trust. It is high time that the state government institutes appropriate inquiries, take such steps as are necessary to eliminate fictitious dealer from the field and also take strong action against the person connected with such matters so that there is no recurrence in its future.
Yes.
Now, the next judgment, my lord, you will simply see. Page 35 is decision of Delhi High Court, my lord. And you will also kindly see paragraph, page 40, paragraph 27, 26. 26. 27, my lord. Married, my lord.
Yes.
It was submitted by so-and-so that there would be a practical difficulty in the so-and-so seeking to inform every selling dealer in the country of the cancellation of registration or purchase dealer registered under the CST Act in Delhi, and that the remedy of the selling dealer in such instance would be proceed against the purchasing dealers. In the considered view of the court, if the selling dealer, after making a diligent inquiry, confirmed that on the date on the sale, the purchasing dealer held a valid CST registration and he also issued a valid C form, then such selling dealer cannot later on hold that the C form is invalid. You will also note it. Since the CST registration of purchasing dealer has been retrospectively cancelled, where a selling dealer failed to make diligent inquiries and proceeds to sell goods or purchasing dealer, which does not on the date of such sale hold valid CST registration, then such dealer cannot later on be seen to protest against the cancellation of the C form. As observed by the Supreme Court in Commission of so-and-so, the selling dealer in such instances will have to pay for his recklessness. So, if the prior to making the sale, the C form is cancelled or the registration is cancelled, then the selling dealer will have to suffer. But if on the day of making the sale, the CST registration was valid and the C forms were valid, then, my lord, it has been said, the selling dealer cannot be made to suffer.
Yes.
Now, we'll also kindly see page 41. This is a decision of Madras High Court. What is it? 13, bhai. 13 को दिशा को. मतलब para 14, para 13. Not the 13 दिशा को. This. Para 13 मिलो.
Yes.
In the instant case from perusal of the files, we are unable to find any material pointing out that there was notification in effect has been published in the Gazette of Andhra Pradesh, making it known to the public that the certificate of registration of the registered dealers whose SOP forms had been utilized by the purchasing dealer had been cancelled and that the said registered dealer surrendered the unused C forms to the concerned authority. There is also no material pointing out that such cancellation of registration certificate of the dealers had been duly intimated to the state governments of Tamil Nadu for the due publication in the official gazette. In such state of affairs, there was no plausibility or possibility for the SSC dealers to seize knowledge of the cancellation of registration certificate of those dealers whose C forms had been misused by the purchase dealer of Andhra Pradesh. Such being the case, the SSC dealer cannot at all be deprived of the benefit of the concessional rate of tax as had been done by the authorities, including of the tribunal. Now, in the case, my lord, first time the authority communicated to the Assam authority in 2018, and that too on the version of the purchasing dealer. It simply says that the purchasing dealer has not received the goods, which is contrary to the records, which are all annexed with the writ petition. My lord. The lordship can see page 52. The second paragraph, my lord. The petitioner is aggrieved by the decision of the respondent by department or the government of NCT Delhi in cancelling Form C utilized by it in respect of transactions it has entered into with the registered dealer. The Form C were cancelled on the ground that the dealers were found to bogus notices at the particular point of time. The petitioner contend that the C forms in question were issued in respect of the bona fide transaction when the dealers were duly registered with the department. On the issue in ideal circumstances, this court had held that retrospective cancellation of the C form issued to the dealers covering periods which were genuine transactions were covered by the such C form, as well as the respect of the period cannot be sustained. The court has therefore set aside the cancellation of the C form with retrospective effect in respect of transactions which the dealer actually operated with the valid registrations. Following the judgment of so-and-so, the present petition is entitled to succeed. The respondents are thereby directed to validate the C forms issued to the dealer which they have described as payable so-and-so.
Yes.
One judgment I will place before Lordship lot of the Rajasthan High Court at page 54. And 11 part below at page 79.
Yes.
The second paragraph below. The obligation of a registered dealer selling the goods to another registered dealer is to avail benefit of the tax provided under Section 8(1) is only confined to furnish the prescribed authority in the prescribed manner a declaration duly filled and signed by the registered dealer to whom they sell the goods. Such declaration should contain the prescribed particulars in the prescribed form and manner. Provided to Section 8(4) stipulates that the selling dealer has to furnish such declaration on within prescribed time or within such further time as the authority may, for sufficient reasons, extend. Rule 12 of the central rules provides a form of declaration. The particulars are to be contained therein, the period for which it has to be furnished, consequential loss of the declaration form, and the course to be adopted in that event. However, this provision does not provide for cancellation of the C form issue. You'll also kindly note it. No doubt, Section 13(3) of the CST Act empowers the state to make rules, but with the order rider that the rules should not be inconsistent with the provisions of CST Act and the rules made or by the central government under Section 13(1) to make out the rules to carry out the purpose of the Act. Section 13(4) of the CST Act inter alia provides that in particular and without prejudice to the powers conferred by such subsection 3, the state government may make rules for all or any of the purposes listed therein from clause A to G. Clause E provides that the state government may make rules prescribing the authority from whom the conditions subject to such fees which subject to the payment of which and any form or certificate prescribed under clause A of the first proviso to subsection 2 of section 8 of the declaration prescribed under subsection 1 of section 6A of section 4 of section 8 may be obtained. The manner in which such form is to be kept in custody and the records relating thereto maintained, and the manner in which such form may be used and such certificate or declaration may be furnished. Beyond and in addition to that, no authority has been conferred on the state and therefore can safely be reduced from their power. That no power has been conferred on the state to frame any rule for cancellation of the declaration once validly issued. Rule so-and-so of the Rajasthan rules is thus barred by the lack of legislative competence and does not conform to the CST Act, having exceeded the authority conferred by the state government under which it is purported to be. In view of the answer, we are inclined to hold that the state has no authority to frame a rule providing for cancellation of the validity of the issued C form.
Yes.
So, my lord, there is no power for cancellation of the C form. And even if the C form is declared to absolute, subsequently, it cannot be given a retrospective effect in respect to transactions which have already undertaken. And in this case, my lord, the transactions, the C form is said was fraudulently obtained, which is not correct. And only on the basis that the Haryana dealer, my lord, where from he is stating that the Haryana dealer has not received the goods. Where from the authority writing that the Haryana goods dealer has not received the goods. when all the documents and papers, invoices, the transportation, everything, the payment has been received from bank through bank, how it can be said that the Haryana dealer has not received the goods? There must be some basis of the authority saying that he has not received the goods. So, my lord, and lastly, my lord, that the order which has been passed directed to make payment of the taxes, that is absolutely illegal, because under the act, no power is conferred on the authority to direct any dealer to make payment on taxes without making any assessment of the taxes, and the assessment having not been done, my lord, the impugned letter or direction is absolutely legal. In fact, my lord, I missed some judgment that on the point that levy charge and the assessment and recovery. Here, my lord, without assessment, the recovery proceedings, the direction has been issued to make the recovery. And thereby, in any case, that direction for making payment of the taxes is illegal without jurisdiction. And this is assessment relates to 2015-16. Even as on today also, the assessment has not been completed.
Just quickly take us through the provisions of the Act.
You also may see section 8(4).
Yes.
8(1) and 2 are the rates of taxes, my lord. And section 8(4) speaks of the declaration form which is to be produced. My lord, the provisions of section 1 shall not apply to any sale in course of interstate and commerce unless the dealer selling the goods furnishes to the prescribed authority in the prescribed manner a declaration duly filled and signed by the registered dealer to whom the goods are sold, containing the prescribed particulars in the prescribed form obtained by the prescribed authority. Now, Rule 12, my lord.
12.
My lord. 12(1).
Yes. Rule 12.
Rule 12, my lord, of the registration turnover rules.
Okay. Yes.
It says, my lord, the declaration and the certificate referred to in subsection 4 of section 8 shall be in form C or D respectively. No, lossy mechanism, my lord. Rule 10B.
Rule 12(2).
My lord.
Rule 12(2), perhaps? No.
12(2), I'm sorry.
That is where it is lost.
So that is lost, my lord, that a declaration has to be made. My lord. The declaration and the certificate is referred to in subsection 4 of section shall be formed in so and so respectively, provided that is commencement of the registration that is not required, my lord. The 3 you'll also see.
12(3).
3.
Yeah.
Where declaration form furnished by dealer purchasing the goods or certificate furnished by the government has been lost, the dealer selling the goods may demand from the dealer purchasing the goods, as the case may be, government will purchase the goods, a duplicate of such certificate, and the same shall be furnished with the following declaration.
So there is no provision as to what happens in case of
No,
cancellation.
Cancellation, there is no provision. And I will next note all the papers and documents to show that the road permit was issued, the goods have moved, the transporters, the RR, the details of the bank statements, everything below the payment has been received.
In your case also, no assessment was done.
In this case, at present, no assessment is made. Only the direction was issued in 2018, you make payment. This I am submitting today, my lord, on the basis, my lord, that only a direction was issued and that direction cannot be issued without making any assessment. The matter relates to 2015-16, we are in 2024, no assessment has been made. And perhaps no assessment can be made now.
Become time burden.
I guess.
Well, affidavit we have filed hearing. But my lord, first of all, my lord, I would like to, my lord, raise the issue of maintainability in the present case. Because my lord, neither the dealer in Haryana is a party hearing, nor the my lord tax officers of Gurgaon is a party hearing. Because entire exercise has been carried out pursuant to this letter dated 19/2/2018. And this has been issued by the Gurgaon authority. My lord. They are not the party hearing. Now, in order to have a my lord interstate transaction, there will have to be a my lord seller and a buyer, my lord. In the present case, the taxing authorities in Gurgaon, they have informed that my lord, there was no transaction at all with the buying authority, that is Om Traders Holding. Now, my lord, whether they being a party hearing and my lord admitting before this honorable court that actually there was a transaction of sale and purchase, my lord, this issue cannot be decided by. Because admittedly, there is a document which says that my lord, those documents were fraudulently obtained by somebody in the name of Om Traders.
But on what provisions are you? Where are the provisions for proceeding against the authority? Because you have.
Well, fraud vicious everything, my lord. It's not fraud vicious everything, my lord. After all, it's a matter of public money. 66 crores is involved here in my lord.
No, fraud.
Fraudulently, my lord, they have got the benefit of Form C.
No assessment was made from your.
My lord?
Why no assessment was carried out?
That part, my lord, of course, I will have to.
Been clear if the assessment order was passed.
Even, my lord, to decide this particular case, since he has raised the issue, why, my lord, those parties are not here in my lord?
No, we are only required to, we are not to decide whether that was a genuine transaction or not. We are to decide whether the authorities have the power to cancel it. And what is the effect of
the cancellation? We have not done the cancellation, my lord. We have not cancelled, my lord, Form C.
No, that's right. So
but without, my lord, in order to decide that, my lord, that authority will have to be a party here in my lord.
You have to decide whether an authority has the power under the act and the rules to even cancel it. Whether cancel, not cancel is a separate issue.
Cancellation of Form C.
Form C. If you,
my lord, if the authority informs in the state that, my lord, those have been fraudulently obtained, can we then those
you are demanding tax from the petitioner,
my lord,
on the ground that the C form is not there or cancelled or
yes, my lord.
Whatever. Now that is only on the information given. Have you received any order from the authority saying that it has been cancelled? You have not asked for any order. There is no order available to say that this transaction has been cancelled or fraudulent transaction. You did not carry out any assessment order, assessment proceeding. Must carry out an assessment and then raise the demand. That's the
that part, my lord, of course, I can clarify, my lord.
The procedure prescribed.
Whether that assessment was carried out or not. But, my lord, apparently it's a case, my lord, that, my lord, they fraudulently, because there is a doubt now whether there was actually those goods were, my lord, sold out of state. Might be it has been, my lord, sold within the state. Because there will have to be a transaction.
That doubt of the department has to be reduced to a fact that yes, there was a fraud. These are the evidences.
But that document is otherwise there, my lord. We cannot doubt this particular document issuing by a, my lord, taxing authority of another state.
Correct.
It has not been put to challenge, my lord.
This document.
It has not been put to challenge.
This document has two effects. One is to say that the forms have become obsolete and the C forms have been cancelled.
Properly, my lord, might be, my lord, the words have not been properly, my lord, drafted in this particular applied in this particular letter, but that doesn't mean that, my lord, those reforms will become genuine. Even it says that, my lord, there is no transaction with that particular dealer. All the judgment that has been relied upon, there was a transaction. The purchasing dealer, they committed fraud by giving fake siphon. Whatever judgment that, or some registration has been cancelled after the transactions were
information are
carried
not
out.
here. These information are not here. Has
No,
the state made any endeavor to find out from the Department of Haryana?
My lord, probably it is as per our inquiry, my lord, this particular reply has been furnished by them, my lord.
No, pursuant to that, what is the status? What steps have they taken?
Why, after this letter, why should we, my lord, have
No,
a,
because under
what
the
steps
act,
they have taken against the dealer?
no, under the act, if at the time of purchase,
My lord.
if the selling authority, the selling dealer has to verify only two things: whether the authority, the purchasing dealer is a registered dealer, and whether the C forms are available or not. He is not supposed to go embark into a detailed inquiry to find out. Once on the date, he has found out that yes, these particular uh, uh, things are available. He is a registered dealer and there's a C form. He transacts the sale and he claims the benefit.
But
now, subsequently, if the authority wants to proceed against that dealer, what is the status? Because ultimately, you are not concerned with the purchasing dealer. You are concerned
Yes.
with the selling dealer.
Selling dealer.
So
from our
he's a registered dealer under you. So for a registered dealer, you are required to carry out an assessment. If an assessment would have been carried out properly, then all these facts would have come out. Whether it is there, not there, what has happened, what is the status.
So for assessment, probably, my lord, we won't be inquiring, my lord, with the seller, my lord.
May
at
not
least.
be, but there will be
Or with the
some
purchaser.
investigation from the point
No,
from the
no
department.
act, nowhere prescribes that, my lord, will have to verify.
Oh.
But, my lord, may I read, my lord, subsection 4 of section 8 again, my lord?
Yes.
The provision of subsection 1 shall not apply to any sale in the course of interstate trade or commerce unless the dealer selling the goods furnishes to the prescribed authority in the prescribed manner a declaration duly filled and signed by the registered dealer to whom the goods are sold.
Correct. That has been
Containing
done.
the prescribed particulars in a prescribed form obtained from the purchase prescribed authority.
No, that has been done.
Now, my lord, they are saying that, my lord, these C forms are fake, my lord. And, my lord, so far as the dealer is concerned, he has also most probably informed the, my lord, authorities in Gurgaon that, my lord, there was no transaction with them. There's the difference here in, my lord, from the other judgment. The purchasing dealer has stated that he has no transaction, he has made no transaction with this particular petitioner, my lord. Fraudulently, my lord, probably, my lord, that TIN number and all has been inserted of that particular dealer.
Now, what is the manner of imposition of tax? The tax you are trying to recover, what is the process? Merely on a communication given by state authority from a different state.
My lord.
Can you issue a demand notice for recovery?
Lord,
It should be a proceeding.
Yes, my lord. That I will clarify, my lord. Yes, well, this letter it directly says that you deposit the balance amount since those three forms are observed. That authority, of course, my lord, but this amount of, my lord, 62 crores, my lord, that part is something, my lord, after all, this is public money, my lord. Regularly, without there being a express sale.
You show us some authority that yes, in a given case where it has been declared to be fraudulent or
yes,
non-existent,
we can directly issue a demand notice.
The sales tax authority of the selling dealer state is within its rights to recover the tax.
My lord.
You show us. But this is why this pursuant to this you have changed to VAT. Now you have gone to GST. You're making it more and more stringent. There were certain loopholes in the legislature.
But that technical part, my lord, I will clarify. But, my lord, without there being, my lord, those authorities being party hearing, the issue cannot be, my lord.
No, that's what I was saying. We are not here to find out whether the sale was a genuine sale or a fraudulent sale.
My lord.
Yeah. if that was the manner in which we are, that is what we are supposed to find out, then of course they are necessary parties. What we are supposed to find out is what is the effect, assuming the C form is cancelled under the provisions of the Act.
No,
What is
not
the,
under this act, madam.
what is the position if
Because that
registration
forms have been issued by them, madam, not by us.
correct? So what is the effect on the selling dealer? What is the effect of the in
They will
respect
not
of
get
the
the benefit,
benefits?
madam. They will have to pay full tax, madam, instead of 2%.
For which
Ultimately,
there has
the
to-
C form, madam, by
for
the C
which
form,
there
they
has
are
to
paying
be a,
only
no, no, for
2%.
which there has to be an assessment proceeding, which has not been done admittedly again.
That part I will clarify, madam. So, but technical point is concerned. But regarding, madam, this fraud, madam, whether, madam, this honorable court will, madam, close his eyes, madam, after this has been pointed out.
No, you're not getting the point.
Now, that part I have understood,
We,
madam.
this court is required to find out because the department has not done it.
But there I
You have
have the
relied,
instruction,
you have
madam, to
relied on
say-
a letter, merely a communication.
My lord.
You have not relied on a statutory order of that authority to say that this is an authority order passed by the authorities, therefore we are relying on it. This is by the excise and taxation officer, come assessing authority.
Yes, madam.
Authority.
They are the main authority there, madam. It's not that
Correct.
clear.
But what orders subsequently has been passed?
It
And
has
as
said,
rightly-
madam,
and as
so and so
rightly-
has been cancelled. There may be an order, madam. That's, they have only communicated, informed us by this particular letter. In the second part, it says, in these circumstances, the C forms issued to Om Traders Gurugram has been cancelled.
You get these instructions, let us see.
My lord.
Well, you see page 36
Of
the writ petition.
yes,
This is C form.
yes.
This form is generated at so and so based on the information provided by the form issuing dealer and retained registration with the department. And also you see name of the purchasing dealer Om Traders.
No, these cannot be ascertained now, madam, without they being party
Just
hearing.
please,
Otherwise, my lord, these
This
documents are
form-
there.
this C form, how I procure from the department? Fraudulently,
The letter speaks, my lord.
later may speak anything. Later
No,
may
no,
speak
the
anything.
letter does not say that he is procured. Selling dealer has not procured.
Even purchasing dealer are not procured.
That's the issue, my lord. The
the-
purchasing dealer, and my lord, buying dealer, selling dealer, nobody has, my lord, procured this. Then who has, my lord?
Procure and
That's
showing,
the fraud.
No, it is obtained from the department.
this is online, my lord.
Without that authority being a party, how this can
How
be
I can make a
clarified?
party because this no notice was issued to me. Why I should make them party?
To
It's not my
support the
responsibility.
case of the petitioner, at least it should have been.
They should,
If they are so
they should
confident.
produce.
Why should the petitioner embark on an inquiry? It is for the department to go.
No, not for an inquiry, my lord.
Then for what purpose?
My lord, otherwise, well, how it can be ascertained, my lord? If they are saying that this is a genuine,
You have acted on the document.
of course, my lord, we have
Department has-
acted on upon the
department has acted
document.
on this
Subsequently, it is informed by the same authority that this is a fraud, my lord, fraudulency
Right.
form.
So
We'll have to act upon that also.
necessary follow-up action from the state ought to have been done. Should have been done. You have acted on that.
No, we have acted. That's why on concessional rate, my lord, the petitioner got the benefit, my lord.
That's right.
2%.
So
Subsequently, when it has been informed, my lord.
My lord, all the documents which were annexed with the department, with the petition.
These are fraud documents.
No, which one?
now how can you say it was fraud?
Already, my lord, the authorities have informed.
These are fraud
Without
documents.
waiving party, that's why I'm saying.
Given writing, but these are fraud documents.
That it is stated in the
Whether the
affidavit.
affidavit says that these are fraud
Yes,
documents.
yes, my lord, we have said it in the affidavit.
Department has become nowadays allergy that say to everything fraud.
Not everything in this particular
The
case.
department
Because
is
we
fraud
have-
nowadays.
That's a, my lord, statement. It
Now
should
the
have been made in
department
the.
is fraud. I am saying, when my papers are fraud, department is fraud.
Where an affidavit, man. Let us
You
get an
will file
affidavit.
affidavit first.
No, all right. You get the instructions. We will take it up on next Tuesday.
My lord, 28, some difficulty, man.
Not
Divi-
28.
Tuesday will be 28.
28, okay.
Division means some matters are there, man.
All right. 30.
30. Well, 30.
Can it be on 30?
Yes, yes. 30, man.
30 May.
Yes.
Shall we have it on 30 May?
Yes, any date, my lord, I have no problem at all.
List for hearing on. further
Your
hearing on
lordship may
30.
remember in 101 ITR, the Supreme Court said that the department and the officers who are implementing the tax laws must know the law first. If they don't know, the revenue must suffer. Here, the assessing authority is not aware at all that without making the assessment, I can issue the demand. And they say that we are acting on the Haryana.
Then on 30th, I will clarify.
We'll proceed on that. List the matters for further hearing on 3005. Matters be treated to be parted.
And two words, my lord, in English, one word, sorry, is creating the problems always. And for taxing department, is fraud. Word as if it is a, my lord, anywhere it can be used, whether applicable or not, fraud. Anybody can say fraud.
Yes.
But in this case, my lord, inadvertently, the covering page of the impugned order, my lord, page 20, my lord. That has been left out, my lord. I may be allowed to bring in record the same.
Which page?
Page, my lord, 20, page 20. Actually, on the last occasion, Mr. Kyle raised objections saying, thinking that the same is a non-appellate order, my lord. But the covering page I have.
Yes, Mr. KL.
Let him file, okay.
Mr. T.K. Bakshi, learned counsel for the petitioner. Praise for it is granted. 2 weeks time to file an additional affidavit to bring on record.
The covering page of the impugned.
Certain documents which he submits would be relevant for deciding the present proceedings. Mr. SCKL, learned standing counsel appearing for the GST department, does not object to the prayer made. Matter be listed after 2 weeks.
My lord, interim may continue.
Interim order passed earlier. I think Mr. KL, there's one matter with Mr. D. Saraf. Let's take it up first.
Two matters. But see, this is a covered matter.
What is your item number?
14, Lordship.
14, yes. So covered means the matter is still pending.
Yes, but see, what happened, we have issue notification, we're extending the time limit of taking issue notice. 16. For Lordship, in this case, the matter relating to 16.4, the matter is pending before the Honorable Supreme Court. Because
He's claiming the benefit of input text.
Input text created under section 16.4,
Which
provides
so the virus of the section has been put to challenge.
It was upheld by the Honorable Patna High Court, Lordship.
So against
And
that-
it went up to Supreme Court and it is pending there, Lordship.
And in our High Court also, two writ petitions are pending, Lordship.
Before the division bench.
Division.
In those items, the wires were challenged. In this, the wires has not been
The
challenged.
heard learned counsel for the parties, it is submitted that the virus of section
16.4 CGST Act.
16.4 of the CGST Act is which was upheld by the Patna High Court, is presently pending before the Apex Court. So, similar to writ petitions are also filed before this court and are pending before the appropriate division bench. Stop. Since it is submitted that the issue has been pending, the virus of the section 16.4 has been filed. It's pending before the Apex Court as well as this court. At this state, let notice be issued, returnable 4 weeks.
Yes.
And there is a prayer for interim.
Lordship, the order might not be enforced, Lordship.
The impugned order dated
26/4/24.
page number.
Page number is at Lordship, page 49.
As the court is required to decide on the question of the benefit of input tax credit claimed by the writ petitioner. The impugned order dated 26/4/2024 within bracket annexure F, page 49 of the writ petition, will not be enforced without leave of the court.
Highly obliged, Lordship.
Since Mr. KL appears for the respondent department and notices are waived, our extra copies be furnished within a period of 1 week from today. Matter be listed after the return date.
In this
Yes.
case, I was, Lordship, I was directed to produce the instruction.
What instruction?
Lordship, the main contention of the petitioner is that we have not proceeded on the faceless mode, Lordship. So this is a.
You submit when you are going to submit.
Last paragraph.
What are you challenging here?
Here, my lord, I am challenging two orders. One order is past 148 AD of the Income Tax Act, and the other notice dated 26/3 issued under section 148 of the Act, my lord. First of all, I am taking to your lordship to page 45. This is the order under section 1. This is the order, my lord. And consequent of this order, my lord.
Yes.
Consequent this order, my lord, the notice under section 148 is issued to me that your lordship will find that case.
We have not filed a reply.
No, I have not filed the reply. Against it, I have not filed the reply, but even though earlier I filed the reply, my lord, now your lordship will see at page 52. That is the notice which has been issued
Yes.
under section. May I read it, my lord?
Yes.
I have the following information in your case, or in the case of the person in respect to which you are assessable under the Income Tax Act 1961. Referred to as the Act for Assessment Year 2020-21. Information.
This
in
is
accordance
within
with the-
limitation.
It's within limit.
Yes, that is the within limitation, my lord. And my lord, in this particular case, what has happened, your lordship will see that who has signed it. It is the ITO Ward 1 Big Boy. That is the assessing officer, jurisdictional assessing officer. Whereas the assessment ought to have been done in a faceless manner within the meaning of section 144B and 151 of the Income Tax, 151A of the Income Tax Act, my lord. And this matter is no more res integra, my lord, in view of the two judgments of Bombay High Court, Honorable Bombay High Court, and Andhra Pradesh High Court. That was अरे कॉपी देना दे दिया गया two judgments.
What does it, to what effect?
My to the effect, my lord, first of all, let us come to the Andhra Pradesh High Court judgment, my lord.
Andhra High Court.
Yes.
I have the Bombay High Court judgment here.
No, both the judgments I have given. क्यों दिया नहीं? हाँ? First of all, my lord. From very beginning, my lord.
Yes.
These days of the petitions have been filed excelling the order passed by the respondent number 1, the income tax officer, that is person such by the instruction such for the assessment instruction such under section 148AG of the Income Tax Act. The challenge is also to the consequential notice registered under section 148 of the Income Tax Act as well issued by the respondent number 1 himself. That is the case. So far my case is concerned. My lord, now I am
So
taking.
now it is to be done through a faceless assessment.
Yes. Both the judgments
151A.
151. And for that one, your lordship may come to the judgment of the Bombay High Court, 151A.
No, what was the finding in the Andhra Pradesh?
That the assessment ought to have been made in a faceless manner.
Paragraph.
My lord, your lordship will come. First, Andhra Pradesh High Court judgment, my lord. Your lordship may come to paragraph 35 and 36. That is the conclusion, man. May I read it, my lord? In view of the aforesaid discussion, it is by now very clear that the procedure could be followed by the responding department upon treating the notices issued for reassessment being under section 148A. The subsequent proceedings was mandatorily required to be undertaken under the subsidiary provisions as laid out under the Finance Act 2021. In the absence of which, we are constrained to hold that the procedure adopted by the relevant department is in contravention to the statute that the Finance Act 2021 at the first instance. Second, it is also in direct contravention to the directives issued by the Honorable Supreme Court in the case of Ashish Agrawal Supra, now 36. For all the aforesaid reasons, the impugned notices issued and the proceedings drawn by the responding department is neither tenable nor sustainable. The notices so issued and the procedure adopted being per se illegal deserve to be and are accordingly set aside, passed. As a consequence, all the impugned orders getting passed, the consequential orders passed by the responding department pursuant to the notices issued under section 140 and 140 could also get passed, and it is ordered accordingly. The reason we are passing the consequential order is on the principle that when the initiation of proceeding itself was procedurally wrong, the subsequent orders also get nullified automatically. Now, my lord, your lordship may come to the Bombay High Court's order, my lord, judgment.
So in the line of Ashish Agarwal, why can it not be reviewed?
That is it.
Revived?
That was in relation to the earlier assessment order. Now, my lord, your lordship will come to the Bombay High Court judgment at paragraph 28, page 24. Page 24.
24.
Paragraph 20.
Yes.
My lord, after reading all the concepts, the following issues came up for consideration. We are concerned with sub-paragraph 4, my lord. Whether the impugned order notice that a certain such is invalid and dead in law being issued by the JAO, the jurisdictional assessing officer, as the same was not in accordance with section 151 of the Act. Now, my lord, your lordship will come. The finding or the reasoning which has been at page 62, para 32. Page 62, para 32. In para 32, my lord, this section has been quoted. Now, my lord, the subsequent paragraph.
Yes.
Directly, my lord, I may take your lordship to paragraph 33. The guidelines stated upon by the revenue is not applicable because these guidelines are internal guidelines, as is clear from the endorsement on the first page of guidelines. Confidential divine circulation only. These guidelines are not issued under section 119 of the Act. Any such guideline issued by the CBDT is not binding on petitioner. Further, this guideline is also not binding on respondent as they are contrary to the provisions of the Act and the scheme framed under section 151 of the Act. The effect of the guideline came up for discussion in circumstances wherein this court has yet
This will require some hearing. Yes, Mr. KL, what do you say?
Lordship, may come to section 151A.
Income tax.
में लगाया हुआ है
Section 151, capital A.
Yes.
Married laws. Faceless assessment of income escaping assessment.
Hmm.
The central government may make a scheme by notification in the official gazette for the purpose of assessment, reassessment, or recomputation under section 147 or issuance of notice under section 148 or conducting inquiry of issuance of so cause notice or passing of an order under section 148 capital A or sanction or issue of such notice under section 151 so as to impart greater efficiency, transparency, and accountability. And one, eliminating the interference between income tax authority and the SSC on any other person to the extent technologically feasible. Now, B, optimizing utilization of the resources through economic of scale and functional specialization. And C, introducing a theme-based assessment, reassessment or recomputation or issuance of section notice with dynamic jurisdiction. So Lordship, the main purpose of introducing this section to eliminate the interference of the authorities, Lordship. Here, Lordship, everything was sent to the notice and all 148 proceedings initiated online, Lordship. And there is nothing has been mentioned about the authorities, Lordship. And Lordship, recently, Delhi High Court, I've given the copy in paragraph 60 and 61.
No, the grievance of the petitioner is that it is issued by the ITO.
Yes, Lordship. But Lordship may please to see in my note section, Lordship, last paragraph. Married Lord.
Yes.
Last paragraph, thus it is seen that the section 151 does not make any reference of either JAO or FAQ and only state that the proceeding are to be conducted, eliminating any interference between the department and authorities, the SSC to the extent technologically feasible. This direction has been.
Where is that scheme? Is there a scheme under
Yes,
this?
scheme is
Yes,
there.
my lord, I have it.
Scheme is there.
My
And
lord,
Lordship,
your lordship will see at page page 57, 55 and there are two schemes, 55 and 57.
So how have these notices been issued?
Through online.
What is the meaning of faceless manner?
Not in faceless, though it was issued on online, but the name of the IT was there. If faceless means I do, there must be that.
Faceless
It
means
may allocate to some other person.
no, not some other person. You have to get it done through a centrally administered system.
Lordship has placed the section and the scheme is before Lordship. Now,
It is like that centralized notices which
Yes,
come.
yes,
It has to be something like that.
Lordship, but here, as per my instruction, nothing was issued physical mode. Everything has been issued faceless. Lordship, we come to paragraph 60 and 61 of Delhi High Court judgment, Lordship.
Yes.
Passed by the division bench of Delhi High Court, paragraph 60 and 61.
'60 and '61.
Page 40, Lordship.
Yes.
Heading is no SSC has any fundamental or vested legal right to be assessed by a faceless assessing officer by virtue of amendment in section 143 capital A and 143B This court is also of the opinion that non-SSC has any fundamental vested legal right to be assessed by faceless assessing
No, but
officer.
that is, where a scheme is not framed. Here a scheme is framed.
No, scheme, in this case, Lordship, before the scheme was framed,
Uh,
the judgment is after, whether it is considered or not, I'm not aware, Lordship. Just now I've got the judgment, Lordship.
The mandate of the act is very clear.
Yes, Lordship.
151A.
151A, what's the purpose of the
Central government may make a scheme.
Lordship A, 151 capital A, the purpose of, this is the purpose, Lordship. When introducing this section, Lordship. Eliminating the interference between the income tax authority and the SEC or any other persons to the extent technologically feasible.
That's right.
So Lordship, here, everything was.
Now, if you have issued a notice, they have to submit a reply.
Yes.
Before whom?
Before the Lordship online through the officer before who has issued the notice.
That's right. So making it online does not mean faceless.
No, Lordship, that's why I'm relying on this judgment of Delhi High Court.
No, but if you have framed a scheme, then it has to go as per scheme. If you have not framed a scheme, then the question of Delhi High Court will come in.
No, Lordship, when the Delhi High Court passed the judgment, the scheme was there.
Maybe in the facts of that case, but do you have a scheme for this northeastern region or not? And what does your scheme say? If you have a scheme,
It will be automatically allotted to some officer whose name will not be reflected in the notice. This is the only difference.
that's right, but the name is declared in the
So,
notice.
Lordship, the question will come, what prejudice has been caused to them?
So prejudice is that 151A.
Even the
Act is not followed.
scheme is there. And whether any interference is there between the officers.
Forget prejudice. There is a mandate of the act. Under the act, you have framed a scheme. Now you have to answer why you don't follow the scheme.
Lordship, my instruction is this, Lordship, last paragraph.
Instruction is not very convincing. E-filing is different.
Does the provision of section 151 relates to elimination of direct? Nothing
This
was.
is like a system where these objections are raised and then notices are issued through the system.
And Lordship, further.
As and when the replies are filed.
They have not taken any plea of faceless at the relevant time.
Who?
SSC. In his reply, he has not raised this point.
They have filed.
Yes, they filed. And thereafter, the 148 notice was issued directing them to file their return within 90 days.
The department is proceeding that it is to eliminate physical interface.
Yes, that was
but
not there.
online interface is permissible. What is the meaning of
No,
that?
no, Lordship, there was no interference at all. And that could have been, Lordship, let them.
This is what your instruction says. Provisions of section 151A
Relates
relate
to-
to elimination of direct
physical interference
physical
between the.
interface
And does
and
not.
does not distinguish between conflict.
In consideration of the jurisdiction for issuing notice. provided
Then you come to the sentence above that the entire proceeding has been conducted via the
by
e-filing.
e-filing portal and assessing an SSC through which the communications has been delivered to and received from the SSC. And Lordship, probably the petitioner has not raised this point before at the relevant time, Lordship. What prejudice has been caused, what rights has been, his right has been violated.
Mandatory prejudice are violated. Where is the question of prejudice,
The
my lord?
department will have to decide how the notices are to be issued. If you want to issue physically, you issue physically.
No, that is.
If you are not issuing physically,
No,
then
that
you
is-
want to invoke the provisions of the 150A, 1A and the scheme, then you implement it. First, the scheme, you produce the scheme in detail, let us find. What is there?
No, that is all right. I'm not denying to that. Everything is there.
Then
Lordship, then next question. When we'll interpret section 151, capital A, subclause A. The purpose of this is Lordship and the entire process.
Eliminating the interface.
Yes, interference.
Not between the officer, income tax authority.
Yes, Lordship, that is.
and the SSE or any other person to the
Yes, no.
extent technologically feasible.
There was no interference from the authority and he has, after receiving the notice on e-portal, he replied to that. Lord.
See, the authority, the particular officer has issued a notice. His name is reflected.
It is there.
So he knows to whom the notices have been sent.
No, that is
The SSE knows that this is the officer who is supposed to review
then
and
Lordship,
go back, reopen my assessment.
he has submitted to his jurisdiction. He filed the reply also. He filed also his reply also, Lord.
And look at clause C, introducing a team-based assessment,
Team-based assessment, reassessment,
which means the purpose is not to give the powers to only one assessing officer.
No, correct, Lordship. That time the scheme is there.
Then if the scheme is there, you follow the scheme.
Name of the officer should not be reflected in the.
Well, then
This is
why are you asking the petitioner to show prejudice?
No, Lordship, he submitted, if he could have raised, clear the first instance.
He's raising it now, you take steps, we'll close the writ petition. You withdraw these notices and issue fresh through your system.
Okay, that may be. That may be, Lord. Will do as per scheme.
But where is the scheme?
The scheme is there. You have annexed
It's
it.
only a part of this.
No, probably it is the entire scheme has been annexed.
Where is the scheme?
At page
Page 55.
55 and 56.
55.
Yes, Lord.
And
Page 55. Probably relevant is page 57. Page 57, clause 3.
Okay, heard learned counsel for the parties. This writ petition is filed with the petitioner, putting to challenge the impugned notice dated.
There are two notices, madam. Both are
Page numbers.
Page 45 and page 52, madam.
45.
Yes.
Impugned notice dated 26/3/2024, annexure F and
H at page 52.
50.
50.
52.
52. Again, another notice dated 26/3/2024, annexure H, page 52, whereby the proceedings, whereby the income tax authority had sought to reopen the assessment under section 147 of the Income Tax Act. Stop. Learned counsel for the petitioner submits that in both the notices, the name of the income tax officer, who is the who is the assessing officer, has been reflected. Stop. This particular notice reflecting the name of the income tax officer, concerned income tax officer, is contrary to the provisions of section 151 capital A and the schemes framed thereunder, whereby the income tax authority was required to undertake these proceedings in a faceless, within quotes, manner. Stop. referring to section 151 capital A, learned counsel for the petitioner submits that this particular provision was inserted in the statute with effect from 1/11/2020 and under the provisions of this act for the purposes of assessment, reassessment or recomputation under section 147 or issuance of notice under section 148. The government, central government may make a scheme by notification in the official gazette reflecting the manner and the procedure for issuance of notice. Stop. The section 151A was brought into the statute to eliminate interface between the income tax authority and the SSE to the extent technologically feasible. Stop. It is further submitted that pursuant to the, in terms of section 151 capital A, the schemes have been brought into effect by the Ministry of Finance, whereby automated allocation and was automated allocation and automated allocation with in accordance with risk management strategy formulated by the board for issuance of notice and in a faceless manner has been brought into effect. Stop. Learned counsel for the petitioner submits that perusal of these notices reveal that the same was not proceeded by the department under the schemes framed under section 151 capital A. He therefore submits that this is violative of the statutory provisions and in support thereof he is relied upon the judgment of the Bombay High Court rendered in Hexaware Technologies Limited by the judgment and order dated 3rd of May 2024 in WPC 1778 of 2023, as well as the judgment of the Andhra Pradesh High Court dated 14/9/2023, passed in a bunch of writ petitions. Stop. Learned counsel for the petitioner submits that both these judgments have held that it was mandatory for the department to follow the procedure prescribed under the scheme framed under the 151 capital A of the Income Tax Act. Par contra, Mr. SCKL, the standing counsel for the department, submits that as permitted by the court, he has obtained these instructions, and as per the instructions, he submits that the notices were issued online and there was no physical interface between the SSE and the department, and therefore the impugn notices issued are valid. And the petitioner, stop. It is further submitted that the writ petitioner, having responded to the notice by filing their written objections, did not raise this issue before the departmental authorities. Stop. He, however, fairly submits that the department has framed the scheme and the same is as and does not dispute the copies enclosed to the writ petition. does not dispute to the copies of the scheme enclosed to the writ petition. Well, learned counsels for the parties have been heard, leading to the report have been carefully perused. The short point involved in the writ petition is whether, in terms of the scheme framed under section 151, the department is required to issue notices in a faceless manner, as has been sought to be undertaken by the department in terms of the provisions of the section 151 capital A of the Income Tax Act. Stop. Para. Section 151 capital A of the Income Tax Act provides for as under extract. Stop. Under the said provisions of the Act, the schemes by the Ministry of Finance have already been framed. Stop. The scheme relevant for this purpose was brought in by notification dated 29th of March 2022. The scheme is called the E-Assessment of Income Escaping Assessment Scheme 2022. The scheme reads as under extract page 57. So, a careful perusal of the scheme reveals that the scope of the scheme is for the purpose of assessment, reassessment, recomputation under section 147 of the Act and issuance of notices under section 148 of the Act. And the same shall be by a process through automated allocation in accordance with the risk management strategy formulated by the board as referred to under section 148 of the Act for issuance of the notice and in a faceless manner, and to the extent provided under section 144 capital B of the Act with reference to make the assessment, reassessment of total income or loss of the SSC. Stop. Perusal of the section 151A along with the scheme reveals that the statute, in order to obviate prejudice and bias, has resorted to issuance of notices by the automated allocation through the risk management strategy. Stop. The judgments referred to by the learned counsel for the petition supports the contention raised by the writ petition and holds that the notices are required to be issued in an automated manner without there being any interface between the department and the SSC. Stop. The judgment relied upon by the learned counsel for the respondent, discusses an issue as to whether there is any vested or fundamental right in respect of the SSC to demand for automated issuance of notices. Stop. The Delhi High Court, by judgment and order dated so and so, has categorically held that there is no fundamental rights or fundamental rights or legal rights available to an SSC to reject of an SSC to demand that the notices through automated automated interface, automated digital interface is required to be automated. Digital allocation should be issued. Stop. Parent. The question of whether the petitioner has the fundamental right or not may not be required to be answered in the present proceedings, in as much as Mr. Keal has fairly submitted that in terms of the provisions under section 151 capital A, the department has already framed the scheme and the same is notified by notification dated 29th of March 2022, Annexure J to the writ petition. Stop. As discussed above, the scope of the scheme has been is for the purposes of assessment, reassessment, computation under section 147 and for issuance of notices under 148, and which shall be done through automated allocation by the department. Stop. If that be so, then the department is required to follow the procedure prescribed in terms of the scheme. Stop. And accordingly, the department may proceed to recall the impugned notices issued to the writ petitioner and issue fresh.
My lord, that is the quas.
Why?
Because because they are against the provisions of the
You are
law, my lord.
aggrieved by the procedure not followed. Quashing will mean that there is no right to issue you a notice. We have not dealt with this issue. Quashing will require a finding that the notices could not have been issued.
Yes, that is my submission.
But that submission has to be supported by the arguments. Where have you made the argument? You are relying on the judgments to say that the notices must be issued through automated interface.
No, because both the judgments, my lord, cover that aspect. So that let the notice may kindly be issued in this particular case. Instead, these two notices after that, the
No,
entire
no.
matter may be had.
We have dictated, we have heard you, we have gone through the judgments. Where is the scope to now stay the notices? This is your argument that this scheme, as per the scheme, it has not been followed. So is it a ground, will it be sufficient to quash it? Quashing will require that the officers did not have the required information, application of bind, etc. under 140, to proceed under 147 by issuing notice under 148.
Yes, my lord, all these things have to be. For that one, your lordship may issue the notice of motion, and in the meantime, both the notices may kindly be stayed.
No,
And
here the
matter may be had
first
also.
objection is that these notices are not as per the scheme.
Yes.
So for you to proceed and file reply, etc.,
Reply I have already filed. Much earlier, reply I have annexed with my petition.
then why did you argue this issue? You should have argued that there was no material before the court. That was not your argument.
No, that was my argument that the notices which have been issued, they are violative of section 141.
That's right. We are dictating that judgment only. We are accepting your arguments that yes, they're violative of 141, but will it be a reason to quash the entire proceedings? It's only the notices that you are aggrieved with, not the proceedings. Proceedings with exactly the proceedings is they are at liberty to issue fresh notice if they want to.
Then your lordship may dictate. Then your lordship may dictate your.
Accordingly, the liberty to withdraw the notices and thereafter issue notices, fresh notices, if permissible under law, as per the scheme dated so and so, read with section 151 capital A. Stop. You want to file a fresh reply in case notices are there, or you want to rely on the earlier?
Definitely, I will.
In the event the department proceeds to issue fresh notices, then the petitioner shall also be granted liberty to file their appropriate reply under the provisions of section 148. Writ petition allowed, disposed of in terms of the above.
Much of it. Much.
Number 18.
judgment has been.
But I'm not. In this case, Lordship, I need 2 weeks time, Lordship.
Yes,
No,
2
this-
weeks
this,
time.
Lordship, with the deputy commissioner, my lord, because the respondent number one has already filed his affidavit.
Yes, we have 5.
The only issue is, my lord, regarding some clarification to be given by the deputy commissioner. That is the only issue.
So what is the reply of the deputy commissioner?
That, my lord, they have to place on record. The revenue has said that regarding the allotment of land in favor of the petitioner, they had sought certain details because the allotment was made by the.
So let him get the detail.
Yes.
Learned counsel appearing for the revenue department, you are for the revenue.
I am for it.
You are for the revenue. What information do you want?
So why don't we have, we have.
No, I'm asking the counsel for the government advocate.
Lordship, that is whether proposal is for allotment or settlement, Lordship.
Is there no reference to that in the affidavit filed with the revenue?
No, the
It
revenue is
refers
in
to
doubt.
both, Mike. In the letter, they have, while forwarding the proposal of the Land Advisory Committee, they have used the term both, Mike, settlement and allotment in the same communication.
Page 48, that is creating the confusion.
No, page 56 in our affidavit, Mike.
No, no, petitioner was.
Asset.
Page
56 of our affidavit, running page 56.
Yes.
This is the
Settlement of land.
And the first line, my lord,
Hmm.
with reference to the subject cited above, I have the honor to send herewith a proposal for allotment.
Oh.
Measuring so and so. So is it whether for allotment
Then the penultimate paragraph is for settlement.
for settlement, madam? It cannot be both, madam. Initially, as per land policy, madam, government provides allotment for 3 years. And if the person who is given allotment, if he uses the land for that particular purpose, if he fulfills, and then settlement is granted.
But this prayer petition is enclosed here.
No, the deputy commissioner needs to clarify whether the proposal is for.
This communication was addressed to the revenue department.
Yes.
Now kindly see this, it encloses the prayer petition. So if the revenue department, you have received this communication, it must be enclosed by the, it must also contain the prayer petition. It will be revealed from there.
Difficulty, my lord. That clarification needs to come from the deputy commissioner.
Why? The prayer petition is there. You only want to know whether the prayer is for allotment or settlement.
No, prayer petition from the petitioner side, my lord.
Right.
But the decision of the SDLSC should be either to allot or to settlement.
That is also enclosed here, resolution copy.
Perhaps that is not clear regarding whether it is allotment or settlement. Therefore, the clarification is.
On what basis you have filed the affidavit?
Look, page 46, 47 says allotment only. The term abandon is used.
Abandon.
Generally, it is the word translates into allotment only, not the.
So it is for allotment.
Yes.
You have made a statement in para 7.
Because after 3 years, my lord, it will settlement will be a consequence step after 3 years. Initially, it has to be the word allotment only.
What is your prayer? What do you want?
I'm for allotment because the first stage has to be necessarily the allotment only. And after 3 years, my lord, it will.
Okay, you produce the SDLSE minutes. The government advocate is permitted to complete instructions and place before the court the SDLSE minutes or / resolution in respect of the settlement / allotment proposal of the writ petitioner. Sri Sukrit Mohan Pandit. Stop.
Lordship, that SLDC meeting, that is 10 to 11, Lordship.
SLDC meeting, minutes of the meeting held 10
to 11.
10 to 2011.
Lordship.
Let the resolution be placed before the court within a period of 2 weeks.
Lordship.
Can a date be?
Any date after 2 weeks to be listed by the registry. Registry will fix a date and list the matter after 2 weeks. Mr. Ray Bhattacharya, appears for the revenue department. Yes.
Much obliged.
We want to withdraw the petitions, madam, 19 and 20. We withdraw.
Withdraw.
Registration is restored, madam.
It is submitted by the MSN Gogoi Learned Counsel appearing for the writ petitioner that the grievances of the writ petitioners have been redressed and they seek to withdraw the writ petitions. Accordingly, the same stands dismissed on withdrawal. Interim orders, if any, stands vacated. Mr. A. Cholia for the
Lordship will
final.
record Mr. B. Gogoi. Lordship, he is in court one, Lordship. Lordship may record.
Why? What is the problem in recording your name?
Lordship, I'm not
You're
the
not
standing
supposed to be
counsel for
present
finance.
here.
No, Lordship, finance and taxation, Lordship, Mr. B. Gogoi is.
Mr. B. Gogoi. Mr. A. Cholia appears on behalf of Mr. B. Gogoi. That's all.
Hi.
May I please, Your Lordship? Well, matter pertains to non-issuance of Aadhaar card. My lord, petitioner as many as 4 times, my lord, he applied for Aadhaar card, but
yes.
Lordship, we have just received the signed copy of additional affidavit, Lordship. Lordship, may please kindly give us some time to furnish the copy to the petitioner, Lordship. And
Signed copy of who? Filed by?
filed by respondent number 1, 3, and 4, Lordship.
my lord, already an affidavit has been filed, my lord. By the respondent number, my lord.
I'm appearing for one.
Your one.
Respondent number 1.
You're appearing for which respondent, madam?
1, 3, and 4.
Lordship, for one, I'm appearing, madam. Our name is not shown, madam.
One. You're
I'm
appearing for one.
my lord. Our name is not shown. I just thought I've been informed, madam.
3 and 4, 2, 3, and 4.
You are confused.
Not exactly, but we have, since the beginning, we have been appearing for 1, 2, and 3, and 4. But just now he has received.
My lord, I'm appearing for 2, my lord. Now I've been appearing for 2. Apologies, madam.
1, 3, and 4.
1, 3, and 4.
Lordship, the similar matter in the nature of present one is already pending for adjudication before the Honorable Supreme Court, Lordship. And a total number of 9.5 lakh Aadhaar card has been pending.
What is the issue and what affidavit are you referring to? You mentioned some affidavit you have received.
Lordship.
What affidavit? Whose affidavit?
Kapil Jamal Khar, Lordship. For respondent number 1.
So that is filed by your client.
Lordship.
Yes, then
Will file during the course of the day, Lordship.
it is already here. One affidavit is already here. You're filing another affidavit.
Lordship.
Okay.
Additional affidavit. Lord.
Learned counsel appearing for the respondents 1, 3, and 4.
Lordship.
Submits that an additional affidavit is required to be filed on behalf of the respondents, and the same is likely to be filed during the course of the day. She prays for the matter to be listed after 2 weeks.
Lordship.
Mr.
A. Fukan for respondent number 2.
The counsel appears for the A.H.M.R. Chaudhary for the petitioner, Mr. A. Fukan for respondent number
2, my lord. Our name may be reflected, my lord.
Take note.
SCGAD.
You take notice of this order and mark it in your diary.
My lord, what happened? No name, my lord. That's why we could.
No name, you maintain a diary. All names can be reflected in the cause list.
No problem is, my lord. My lord, since our name is not reflected, my lord, we don't have the brief also. I mean, they've not given us a copy.
The copy was sad, otherwise.
Because
matter
SCGAD is
would
not
have
shown.
been listed, my lord.
SCGAD should have been shown. That is why, my lord, I've said.
Otherwise, my lord.
SCGAD, they must have given it to the government advocate, my lord. Not we are standing counsel, my lord, appearing for the GAD department.
It is submitted by Mr. Fukan that the copies have not been served on the standing counsel for respondent number 1. The learned counsel for the petitioner will take steps to serve extra copies of the petitioner within a period of 1 week from today.
If you
Lordship, in this case, Lordship, I'm for respondent, Lordship. And we have sent the affidavit for vetting, Lordship. Within 1 week, we will file, Lordship.
I appear for petition.
You can't have an objection because this is the submission which you normally give. So he has borrowed it from you. Learned government advocate and Mr. Dan Goswami, we has praised for 2 weeks' time to file the affidavit on behalf of the respondent. Mr. Rai Portagur, learned counsel to the petitioner, does not object. Yes. AC to monocle. None appears for the petitioner. You are appearing for higher education.
Revenue and disbursement.
Revenue and legal.
Please, your lordship.
Yes.
Actually, the deputy commissioner Barpeta has already admitted our entitlement. And also, deputy commissioner has already admitted our entitlement and amount in his affidavit in opposition. Also, but due to lack of funds from the revenue and management, disaster management department, payment to us could not be made. Now it is in the revenue and disaster management who is the authority to release the amount. Matter relates.
No, there is some
Yes, my lord.
communication here.
Yes, that has been.
Have you seen it?
Sunday.
Do you have a copy? This is with effect from 1811.
My lord?
1811, you have stopped the scheme.
Yes, my lord.
What happens now?
Now we're seeking new guidelines from the government of India, my lord, to frame the new policy, my lord.
Yes. No, are there applications considered, not considered?
Considered, lordship.
They say considered.
No, my lord. Not, cannot be, my lord. Now policy is not enforced, my lord. Their policy.
Learned counsel representing the revenue department submits that the earlier policies for rehabilitation of erosion affected people have been rescinded by the notification number so and so dated 18/11/2023, and a new policy will be framed after receipt of guidelines from the government of India. Stop. In view of such submissions, learned counsel for the petitioner submits that she'd like to obtain the required instructions. Praise for 2 weeks further time. List after 2 weeks. A date to be fixed by the registry.
In this case, we have filed one affidavit to their lordship.
It is submitted by the learned government advocate that the affidavit on behalf of the respondents have been filed today. The same, however, is not enclosed to the writ petition. Registry to verify and connect the same and list the matter again after 2 weeks.
In this case, respondent number 1, 2, 3, they have filed their affidavit. I have checked the record, the affidavit is not yet here.
Who has filed?
The respondent number 1, 2, 3, and I'm a public petitioner. So some time is required to file a affidavit.
The affidavits are not here.
Not here.
It is submitted by the learned counsel for the petitioner, Mr. Chetri, that the affidavits on behalf of respondents 1, 2, and 3 have been filed. Stop. However, the same are not available in the case records. Now, if that be so, same are, however, not available in the case records. The registry is to verify and connect the said affidavits stated to have been filed and can list the matter after 2 weeks.
Item 30 is the same.
There also affidavits filed.
Yes.
Not available on case record.
Yes.
2930.
Obligation.
Yes.
Please, your lordship. Lordship, this writ was done for setting aside of a Kula Talak. The previous there were two more writ petition were there, which were already disposed of, letting us know that as this was already cancelled by the Kazi, that's why. But we challenging this writ that as the Kula Talak was cannot be cancelled by the Kazi. But in WBC 1114/2023, those readings got disposed. As they have withdrawn cancelled the Kula Talak.
What is a Kula Talak?
Kula Talak is given by Kazi.
Yes, so what is to be done today? Who appears for the respondents?
Minded, the act is now no longer in existence.
Muslim marriages.
Yes.
Registration one. Oh,
The 1935 act is gone.
right. So
And that is being put to challenge before the division bench. That is pending. So in view of that, kind of whether it is repetition is maintainable or not, that your lordship has to, that the petitioner has to address the.
it was only at the stage of notices.
Yes.
No order was passed.
No, Kula Talak was given, notice was, yes, in the stage of notice. Those two petitions were one that there was a stay order given by this court, and after that also third notice was given, issued against us.
You submit respondents whether it is infractious or not. You tell us.
Well, that petition is right now, I don't have.
No. That notification, okay, but even if the notification is taken, because these orders were issued prior to the notification. So therefore, whether any adjudication at this stage is necessary or not. For you to address. If not, we are closing it.
Yes, lordship may kindly grant us some time. This case will day and will appeal.
Heard learned counsel for the petitioner, Mr. M.S.S. Borua for
Respondent number 2 and 3.
respondent 2 and 3, and Mr. Rebot Chatty for
Number 1.
1.
Lordship, extra copy not served to us.
It is submitted that the Muslim Marriages and Divorces Registration Act 1935, under which the orders and the notices, orders passed and the notices issued have been assailed in the writ petition, has since been is no longer in force, and the same has been held to be rescinded. Do you have the notification number?
Right now, I do not.
By the government of Assam, by way of appropriate notification. Stop. Learned government advocate therefore craves leave of the court to place the said notification and address the court regarding the maintenance of the writ petition at pursuant to the acts being rescinded. List after 2 weeks.
Depends on that, there is
Huh? Huh.
Original diary of the state petition order from N5 31 is 22 and from 1 to 24 to 34 22.
He brought everything, like Hanuman. Where is that concerned? What do you call that? Case diary for this matter? Oh, general diary. Okay. Okay. So you see and tell us from the general diary what is recorded there in respect of this case. Tell us. Go through it and tell us. We'll take it up after a while again.
My lord, I have filed this writ petition for adequate compensation. The DC has filed affidavit. From the affidavit, it appears that they have paid something. But they have paid some amount to the petitioner.
Right.
Now, it is not within my knowledge. I contacted the petitioner, but not found. So, Lordship may kindly fix the matter after 1 week. In the meantime, I'll collect.
Some affidavit has been filed.
My lord?
So you said some affidavit is filed.
Affidavit is filed, and in affidavit they said that we have paid rupees 20,000, some 20,000.
The affidavit is not available here. Anyway, it is submitted by Mr. M.U. Mahmood that the Deputy Commissioner's office has filed an affidavit stating that some amount has been
20,164.
amounting to 20,164 to the writ petitioner. So, the Honored Counsel for the petitioner submits that he would like to complete his instructions in this respect. And he therefore prays for 3 weeks' time. Mr. C. Borua appears for
2 and 7 Miller. I also filed affidavit.
appears for 2 and 7. He also submits that he'd like to file an affidavit. MS S. Borua appears for respondent number 456. Revenue Department, Mr. A. Bhattacharya from Revenue Department. Yes, Union of India. Your name, please. A. Dekha for respondent number 1. You are for 2.
Only 3 appearing 1, 2.
Who is appearing for 2?
1. 1 3 can appear. 2 will appear. National Highway. 1 and 3 will appear.
3. No.
No, Secretary Dr. Vidya.
No. 3 is Secretary Government of Assam.
What it is the Dr. Vidya?
Oh, no. Revenue and Disaster Management.
3.
Here the corrections are made by hand.
Oh, correct. Then I am being for 2 and 7 Miller. I'm clear on that.
Yes. Let the matter be listed after 3 weeks. Meanwhile, registry to verify, registry to trace out the affidavit stated to have been filed by the Deputy Commissioner's office and connected to the case record. Case record.
Lordship, this is regarding forest LD we paid by the petitioner while applying for building permission. Already interpretation is allowed, Lordship.
Who's for the respondent? Yes.
I for the forest department. Otherwise, the notification has been issued. It is standing for communication by mines and minerals department. And there's a batch of writ petitions led by petition 2040/2023. This is the
It is submitted at the bar that a similar petitions are pending and concerning the same issues, namely that as to whether the writ petitioners are liable to make payment of forest royalty under the Assam Minor Minerals Concession Rules 2013. So it is submitted that this writ petition be directed to be listed along with the PPC number
2040
2040 of 2020
Three.
2023 and the other bunch of writ petitions. In view of the submissions made at the bar registry to connect this writ petition and along with the bunch of writ petitions where the lead case is 2040 of 2020.
Interim order shall continue.
Some interim order is there.
Yes, 8/1/24.
The interim order passed on 8/1/2024 will continue. Yeah.
Most of it.
May it please your lordship. Lordship, this writ petition is filed by the petitioner against the police in action, lordship. The respondent authorities were to seek instruction.
Yes, what have you done? You bring it by way of a record, by affidavit. Bring it by affidavit, by way of record. Learned counsel for the respondent, government advocate, appearing for the respondents, submits that the action places before the court the action taken report. Let the report be brought on record by way of an affidavit. MS so-and-so appears on behalf of the writ petition.
Abora.
Let the matter be listed after 3 weeks.
Lordship, a date may be fixed.
After 3 weeks, let them file. You can mention before the
Obliged, lordship.
Yes, what have you found?
Within the no mention about.
Then why no mention is there? Is he aware of, is he familiar with this case? Is the person coming from the police station posted with the instruction?
Yeah. Otherwise, it is law for the cognitive offense there. Police contact the preliminary.
What does the GD say? Is there any reference? Is there any record? Nothing. Then on what basis are you making this statement? On what basis are you making this statement? That some inquiry was done. No, for somebody to make an inquiry, unless there is an entry, how will they know? You show us the relevant portion of the GD.
There is nothing.
That is what we want to see, the relevant period during which it was supposed to be recorded for our satisfaction. Show it to us. You show us the relevant, why are you giving us the entire bunch? When did you file the FIR? You filed it on 10/8/2022. You find out the relevant relevant portion. Why are you giving us the entire bunch? This is what you are supposed to see and submit. What have you done? Why are you making submissions without going through the records?
There is no mention about this case law.
Where have you seen it? That is what I want to see. Okay. Where have you seen it? Show us the portion to support your contention that it is not there. Show us. Show us from the records. Where did you see that? We gave you some time. You submitted that it's not there.
They informed me.
Mr. Counsel, please behave with some responsibility towards the court. We are short of issuing personal appearance for the SP. Pull it out at the end of the list.
May I please, Your Lord? In this case, Your Lordship, the husband of the petitioner had expired due to road traffic accident, and after the untoward incident, Your Lordship, petitioner filed an application to the respondent number 3 for seeking ex gratia relief under the
Yes,
government scheme.
respondents, what do you say?
And
Only recently we have filed an affidavit
So already the application has reached the office of the deputy commissioner, and additional deputy commissioner has also written to the superintendent of police.
You have filed an
to conduct-
affidavit.
Yes. Conduct
You
an
have filed
inquiry.
an affidavit.
We have filed an affidavit. So that part has been made clear that the report from the superintendent of police as
It's
regard
not
the.
here, it's not here. not here.
Yes, we have filed it.
Are you sure you have filed it?
Yes.
27, I have received. It
So
was
you
filed.
may have received, but have you actually filed it?
Yes.
Okay.
Record. May I again re-verify?
It's not here. The affidavit has to be available in the case record. It is submitted,
27th of February, 2020.
it is submitted by
Respondent number 3.
the learned counsel appearing for respondent number 3. That an affidavit has been filed on 27
February.
February 2024. However, the same is not available in the case report. Counsel for the petitioner submits that he has received a copy of the same affidavit filed. Let the registry verify as to whether the affidavit has been filed and connect the same to the case record by the next date. That will be listed after 3 weeks.
Deeply.
Matter is the petitioner is possessing a proper plan. Can you keep during one just select plus from 18 line or without paying any proper compensation and without demarcation, they have to move the petitioner.
Yes, who is appearing? Mr. Bora.
No, during that moment.
Any instruction?
No, we have communicated, but it is awaited. That's all.
Counsel for the respondent number 3. You are appearing for respondent 3.
I'm appearing for respondent number 2. Yes, I'm appearing for respondent number 2 and 4.
2 and 4 submits. The instruction sought for has not yet been received. Therefore, prays for further time. Mr. Bora represents respondent number 1 and 5.
I appear for 1.
1, 3 and 5, sorry.
I appear for 1.
Mr. Bhattacharya for 1.
I appear for respondent 3. TM2.
Mr. Bora appears for respondent 3. Placed after, how much time would you require?
Let it be after 2 weeks.
Placed after 2 weeks.
By this case, we have filed an affidavit today for respondent number 4 and 5. So, the registry has to take it with the record, madam.
So direction on the section 14 of this RPSI Act, very limited really that.
Anyway, he's filed an affidavit. He tagged Mr. A. Das, learned counsel appearing for the respondent 4 and 5, submits that an affidavit has been filed today. However, the same is not connected to the case record. Registry to trace out and connect the same case record. List the matter thereafter. Mr. Khan be appeared for the petitioner list after 2 weeks.
Can a date be fixed? Public money is entered.
10th?
No,
10th
10th, I have some difficulty with any other date. 12th.
12th of June.
May I please? My lord, in this matter, my lord, the order passed in an arbitration proceeding by a tribunal is under challenge, my lord, under Article 227.
Why no appeal is filed?
My lord, actually, my lord, there was a direction by this court under section 11 to decide on the arbitrability of the dispute by the tribunal, my lord, before going into the merits of the case. That was accordingly decided by the tribunal. Against that order, my lord, we have come and my lord, the basic contention, our basic contention is that my lord, the tribunal has referred and decided to go on with the arbitration under a clause, my lord, which is not an arbitration clause at all in the terms of the railway contract agreement. Under that circumstances, my lord, because it will be a futile exercise if the arbitration goes on under a clause which is apparently is not an arbitration clause. That's why, my lord, we are invoking the extraordinary. Otherwise, my lord, the remedy is to challenge under 34. That is a settled law, my lord, that any interim order or interlocutory order by the tribunal that has to be challenged at the after the passing of the award. But here, my lord, the extraordinary situation is this, my lord, that the clause in which the arbitration is going on is apparently is not an arbitration clause.
That also can be appealed against.
Well, but that would be not entire, it will be wastage of time and we have to pay arbitration fee also. With the amount here is around crore in crores, my lord. So the arbitration fee, the railway has to bear, my lord, unnecessarily. Otherwise, my lord, we would not have challenged the order. We would have challenged it in 34 and 37 when the time comes. Now, this is the basic my lord, contention. My lord, page 30. My lord, if we'll see, is the annexure 5, which is the initial demand for arbitration, my lord, raised by them.
Yes.
And my lord, will see the subject, it is demand for arbitration under clause 64(1) of the agreement. And my lord, that was replied to, my lord, at page 38. Now, this is the letter dated 19/8/2020. Page 38 and annexure 6 is the reply, my lord, by which we have stated that the amount claimed is more than 20% of the contract value. Therefore, my lord, in terms of clause 47, the dispute is not arbitrable. Thereafter, my lord, the petitioners approached under section 11 for appointment of an arbitrator, stating that there is a dispute. No, my lord, that proceeding, my lord, the operative part of the section 11 order, my lord, that is at page 71. Paragraph 48. My lord. My lord, the section 11 pre-referral court, my lord, held that in the opinion of this court, when such contentious issues have arisen, more particularly because of incorrect use of the clauses as also admitted by the respondents, railway authorities themselves, court is of view that it would be best left to be decided by the tribunal and also whether the claim raised is arbitrable or not, and not by this court at this referral stage. Well, accordingly, the matter was referred before the arbitral tribunal to be decided. Now, there we filed our detailed arguments and reply. And my lord, the decision of the tribunal was also given thereafter. And at my lord, page
What's the clause?
no, I'll come to clause, my lord. My lord, will take page 134 for a moment, my lord. The last 3 lines, my lord. Page 134, not last 3 lines, the above paragraph 19, my lord, last 3 lines. Thus, my lord has got it. Thus, this tribunal holds that. Not just before paragraph 19, above paragraph 19. Now, thus, this tribunal holds that claimant does not have any right to demand for invoking clause 64.1 of the GCC. Therefore, my lord, it was decided by the tribunal that the only arbitration clause under which the dispute was to be, my lord, should have gone into arbitration, that is not arbitrable. Now, my lord, I will take, my lord, to the relevant clauses. Page, my lord, 41 is the relevant clause of the settlement of disputes for arbitration. 45.0, my lord, it starts from. My lord has got it. page forty-one and eight, my lord, 45.0, settlement of dispute, Indian Railway arbitration rules. 45.1 says, my lord, arbitration and settlement of disputes shall be governed by clause 63, 64 of the general conditions of contract, NF Railway 1998 edition, which are reproduced below, subject to any correction made prior to opening of this tender. Now, this is very categorically, it is the arbitration clause, my lord, which says it is 63 and 64, which will be applicable for referring the disputes to arbitration. Thereafter, my lord, clause 46 is there, which my lord goes on, and my lord will take page 46 now. Now, these clauses are continuing, my lord, after 45 in serial order, 45.1, my lord, then 46 at page 41, and thereafter, my lord will take page 45 at the bottom. That is clause 47. The provisions of clause 63 and 64 of the GCC of the contract will be applicable for settlement of claims and disputes between the parties for value less than or equal to 20% of the value of the contract. And when the claim of the disputes are of value more than 20% of the value of contract, provisions of clauses 63 and 64 and other relevant clauses of the general conditions of contract will not be applicable, and arbitration will not be a remedy for settlement of such disputes. Thereafter, clause 48 says that the contractor shall not be entitled to ask for reference to the arbitration before completion of the work assigned to him under this contract. The contractor shall seek reference to arbitration to settle the dispute only once within the ambit of condition 16.2 above. These special conditions.
What is the mode of remedy for settlement?
My lord, it is 63 and 64.
Your value is more than 20%.
Yes.
There's no dispute on that.
No dispute on that. If value is more than 20%, my lord, then civil court is the only remedy, my lord, because the express bar is there in the contract. And my lord, there is our judgment of this high court also, my lord, wherein this on the 20% issue, the matter was, my lord, rejected, my lord, and the one more copy is there, no? My lord, here, my lord, at 20% issue was, my lord, raised before, as came before the honorable court, my lord, and at paragraph 23, at the pre-referral stage itself, my lord, the court has rejected the arbitration petition under section 11. Paragraph 23, my lord, the claim value was 36.6% above the contract value.
What is clause 46 and 47?
My lord, clause
48 and
47 and 48.
47. Where does one?
My lord, 47 is at page 45, my lord, the bottom, page 45. Page 45 at the bottom, my lord, clause 47 is there. The provisions of clauses 63 and 64 of the GCC will be applicable only for settlement of claims or disputes between the parties for value less than or equal to 20% of the value of the contract. And when the claims of disputes are of value more than 20% of the value of contract, provisions of 63, 64, and other relevant clauses of GCC will not be applicable, and arbitration will not be a remedy for settlement of such.
And what is 49?
49, my lord, says that these special conditions, my lord, these 47 and 48 is a special condition that will prevail over 63 and 64. Clause 63 and 64 is the main arbitration clause.
No. It says special conditions 16.2 and 16.
My lord, 16.23, my lord, this is an, my lord, my lord, the mistake is there in the numbering, my lord. This is in fact 47 and 48. That has been clarified under section 11.
You are saying that there is no clause 16.2 and 16.3.
16.23 is there, my lord, but here the reference of 16.23 is wrongly made. It ought to have been, my lord, 47 and 48.
No, show us where is 16.2 and 3.
Yes. Yeah, High Court order. My lord, page 54.
Yes, right.
My lord, I'm sorry, my lord, it's 2 point, that is, my lord, GCC, my lord, this is the contract agreement. I'm sorry. No, that is all right. But that is general conditions of contract. The 16.23, my lord, is the tender agreement, my lord, that is highlighted in blue, my lord.
Or you can just look into your page number 39.
Why don't you produce a copy of the proper agreement?
Yeah.
So admittedly, the contract is more than 20%.
Yes.
So, 47 says it will be applicable only for settlement of claims and disputes between the parties for value less than or equal to 20%.
Yeah.
And where the claims of disputes are more than 20%.
Yes.
63, 64 not applicable.
My lord.
Then what is the mode of settlement?
In case of they have to either reduce the claim up to the 20% of the contract value. In case of a higher value, they have to approach civil court. And that aspect was, my lord, directed to be decided by the Honorable High Court under Section 11. And while deciding that aspect, my lord, the tribunal held that the rejection under clause 47 by us is right. Although, my lord, the tribunal went ahead and, my lord, took limb of a different clause to go ahead with the arbitration, which is in fact not an arbitration clause in the agreement. That is clause 48. Well, there can be only one arbitration clause in a contract agreement. There cannot be 2, 3 arbitration clauses.
Yes, there can be.
Well, but the bare reading of the clauses, my lord, which from 45 I have read, my lord, in a chronological order.
What is the clause referred to by the tribunal?
That is 48, my lord.
48 and 49, your lordship.
48 and 49.
48 and 49.
But 48 and 49, my lord, has to read in a chronological order starting from 45. 40. Yes. My lord, in my petition, page 41, the clause.
We just found it here.
Yes, it is there also. Page 51, my lord. It starts from 47. Right hand side, my lord, it is marked in bold, my lord, page 47.
Tribunal said it is possible under
48 and 49. But 48 and 49 they are not independent clauses, my lord. It has to be read from 45 onwards. And 45 is the main clause which deals with the arbitration. That categorically says it is clause 63 and 64 is what is the clause which will be governed by for arbitration of disputes.
what is 16.2 again?
16.2, Lord, in the agreement which I have given, Lord. Page 28, my lord, in bold letters, it is on the right hand side top, my lord. Page 28 of the agreement which I have separately given, my lord, 16.2 and 3. That is regarding, my lord, the program of work and time schedule, which the tender has to submit. My lord, the aspect of my lord, wrong quoting of the clause numbers, that at page 54, my lord, before the section 11 quote, there was a detailed affidavit filed by the railways clarifying that one.
Is it 16.2 or what? Special clauses or general clauses?
This is, my lord, the tender agreement, contract agreement.
That is general conditions of contract.
The one which I have given first in the point of time.
16.2 and 3 as shown here has got no relevance with.
That's what, my lord.
47, 48,
Yes.
49.
Your lordship, that has got relevance, that already the arbitrator has given in a detailed description in page number 212 of the affidavit in opposition which we have filed.
200?
212, your lordship, of the affidavit in opposition filed by the respondent. 16.2 and 16.3, your lordship, deals with work progress, submission of work program chart, and we have submitted the work program chart. And clause 48 clearly states that the work
can be referred to arbitration under the ambit of 16.2. So we have completed the assigned work, Your Lordship.
Subject to 20%.
Subject to 20%, it will not be there, Your Lordship, because 49 makes 63 and 64 redundant. That's what, Your Lordship. It clearly says that it shall prevail over clauses 63 and 64. That is what the arbitral tribunal has clearly held, that 63 and 64 are infructuous, my lord. So they have come to the court stating that under 63 and 64, the arbitral tribunal has clearly held that it is not arbitrable under 63 and 64. It is arbitrable under 48 and 49 as per her order.
Okay.
And the contention which they are placing forward that there cannot be two arbitration clauses, Your Lordship, there is no implicit or explicit bar in anywhere which shows that there cannot be more than one arbitration clause. So the arbitrator decided that the matter is arbitrable under clause 48, which the High Court itself, Honorable Justice Koteshwar Singh in his order had asked the arbitrator to decide on her jurisdiction, based on which whether under 63-64 the matter is arbitrable or under 48-49. The arbitrator held that the matter is arbitrable under 48 and 49.
In view of the satisfaction of clause 16.2
Yes, Your Lord.
and 16.3.
Yes, she has clearly defined the word work in a detailed manner, Your Lordship. So there is no ambiguity with regard to the judgment passed by her, Your Lordship.
Another important aspect, if I may just like to add with the permission of Leonard Penn, this paragraph 40, clause 48, my lord, also stated that the contractor shall not be entitled to ask for reference before completion of the work assigned under this contract. Here, my lord, the contractor has asked for the reference before completion of the work. That is
what 16.2 says.
For clause 48. So 48, my lord.
16.2 is submission of the drawings and the
Whatever work was assigned to her, we have to submit the bar chart and we have submitted. Whatever work was assigned to us, we have completed. The arbitral tribunal has also held the same thing.
Here the contract.
So we are correct in going forward with arbitration under 48 and 49, Your Lordship.
So therefore, go in a bit.
Yes, Your Lordship, an alternative remedy is available to them.
Go in a bit. 534.
34.
Why it took the jurisdiction?
Prima facie, my lord, it is clearly apparent that it
Their
is not
application was
maintained.
initially filed under clause 63-64. And that was rejected. Pursuant to that, they came under section 11. So in any view of the matter, reference under 48, 49.
We'll keep it for hearing. All the pleadings are complete?
Yes.
All the pleadings are completed, Your Lordship. If Your Lordship would permit, I would like to argue on the matter if possible today, because the final hearing for the arbitration on first, second, and third.
But here we are praying also for a stay, my lord, and
Because they are paying
another
for a stay in this
difficulty is,
matter,
my
Your
lord,
Lordship.
we have to pay a huge arbitral fee, my lord, that the
It is
railway.
not about your concern, it is your, it's a creature of the agreement.
So prima facie, it doesn't appear, my lord, the arbitration
Your
clause.
Lordship,
This matter is
prepared
posted
the
for,
arbitral.
posted for,
Final hearing.
no, it's not posted for final hearing.
Your Lordship, the arbitral proceeding
Ah,
is posted for final hearing. That's what.
when is it fixed?
First, second, and third of June, Your Lordship. And there is one more thing, Your Lordship, if Your Lordship may permit, I would like to put forward, is they have put forward their counterclaim. Their counterclaim is above 20% of the contract. They themselves are saying, the matter is not arbitrable because our claims are above 20%. They go ahead and go and file a counterclaim above 20%. That is around some 21 CR, Your Lordship. So they have placed their grievances before the arbitrator, right, to adjudicate on their claims. So that has to be heard, Your Lordship. And whatever the jurisdiction issue, that can be raised under the 34 application, Your Lordship.
Correct. Anyway, we'll keep it for 11th of June.
After final hearing of the arbitration.
The hearing, and meanwhile, proceedings under so and so shall remain state.
My lord.
Till the next date.
My lord.
11.
Your
We'll have to
Lord-
decide on this issue.
Yes.
Your lordship, can it be decided today? I'm prepared with my arguments. I
You
would
may
say.
be, but we are not ready to take up the matter for hearing today.
All right, your lordship, you
We
oblige.
can,
Your lordship, can it be placed on 30th of May?
we try 30th,
30th of May, your lordship. Kindly
30th, let it be
kindly
on
be taken
30th,
up on 30th of May.
30th of May.
Obliged,
Finally.
obliged, your lordship.
Then we don't need to pass the interim order. It's on first, isn't it?
Yes, your lordship, it's on first.
We'll keep it on 30th,
Obliged.
placed on 30th for final hearing. Attempt will be made to dispose of the petition.
Till the next date, my lord, maybe otherwise,
It's starting on first,
my lord.
so we are keeping it on 30th.
What has heard is, my lord, otherwise the interim.
It's starting on
My
first.
lord,
We are fixing it before that.
my lord,
If we cannot complete it, we'll consider your interim prayer.
my lord. No, that may be indicated. The interim.
Not necessary to.
Obliged.
Yes.
Deeply
Fixed
obliged,
on
your lordship.
Lordship, we have received a copy of affidavit in opposition filed by the respondent number 2 and 3, Lordship. Lordship, may allow 2 weeks time.
Counsel
file.
for petitioner prays for 2 weeks' time to file rejoinder affidavit. It's to advise. That is for
EMC.
EMC. Mr.
Nepal, or
Nepal.
4, 5, and 6.
For respondents 4, 5, and 6.
But we have not been served this copy of this.
I will file copy.
Serve a copy.
Published.
Obliged.
I please, O Lord. My lord, the matter relates to the compensation, my lord, because the petitioner's house was fully, my lord, damaged by fire, my lord. And he applied, my lord, and then a sanction was also made.
Rules for respondents, revenue department,
Revenue, my lord.
instructions.
I'm awaiting instructions, madam. Sometime may be granted.
The date may kindly be given, my lord.
Mr. A. Bhattacharjee prays for appearing for the revenue department, prays for further time to complete the construction. He prays for 3 weeks' time. Mr. Mullah appears for the reputation. List after 3 weeks.
My lord, may I pray for a date, my lord?
17, 19.
19. Obliged.
May it please your lordship. Lordship, this writ petition is filed by the petitioner challenging the impugned WhatsApp message dated 20 February 2024 issued by the respondent number 7. And lordship, we also challenge the impugned letter dated 20 January 2007 issued by the respondent number 4, which lordship will find at page 69 and 70. Lordship, the case of the petitioner is that, Lordship, the petitioner has been deprived of his legitimate right of easement for not being able to ingress and egress the industrial complex, that is GB Gatani Industrial Complex, which was situated, my lord, at PWD Sinamara Mariani Road, my lord, over a plot of 60 bighas land, my lord. Now, the case of the petitioner is that, my lord, there are 2 railway unmanned level crossing, that is gate number 76/56 and 76/67. And after 1 kilometer, there is another railway man level crossing, that is at 77 kilometer. That is the railway man level crossing. So out of this 2 railway unmanned level crossing, the railway had permanently closed down the unmanned level crossing gates at on, my lord, 23 February 2017. So, my lord, in the notice, they have made an allegation that we trespassing the unauthorized level crossing, which is a false allegation, my lord. Because, lordship, I would like to draw your kind attention to my application, which I have annexed at page 71, annexure 4. This is my first application, which I have issued to the Divisional Railway Manager, NF Railway Tinsukia. Page 71, my lord. This is, Lordship, may I read?
Yes.
Most humbly and respectfully beg to state that I am going to set up 4 SSI units at my land situated at Napamua, Sinamara, just adjacent to the railway tracks, measuring 1250 in parallel at left side on Jorhat Moriani Road. Accordingly, necessary NOCs and provisional certificates for the industrial units have been obtained, and the development and construction work of factory sheds are in progress. The copies of the NOCs issued by local authority enclosed herewith for your perusal.
Who
As
has
the
sent the messages? Who is, you are,
Lordship, the
you are
message,
coming before the court for staying a WhatsApp message.
not only WhatsApp message, my lord, there is one more letter which I have annexed at page 70, my lord. Thereafter, my lord, after filing of this writ petition, they have issued another letter that is which I have not filed it before your lordship, because during the pendency of this writ petition, they issued the fresh one, that is notice dated 8/4/2024, which is not in the
This
record,
is
my lord.
2017 letter.
Yes, my lord.
Then what happened after that?
After that, my lord, public meeting was held, my lord, in the year 2015, that is on 6 June 2015, where certain resolutions were adopted. Lordship may kindly come to page 78.
What have you made unauthorized track crossing?
Yes, as per them, we unauthorized trespassing their level crossing, that which is not correct, my lord. We properly made an application seeking using of this railway crossing, my lord, which is at page, lordship, just now I have mentioned that it is at page page 71. We made prayer for permission for crossing railway tracks to enter my premises. This is my subject, my lord. And thereafter, my lord, a public meeting was held in Lordship DC office, Jorhat, which I have annexed here at page 78. The minutes of the public meeting, my lord. The type copy is at page 78 and the original copy is at page 81.
Yes.
Lordship, the meeting was presided over by Shri Such and Such, and the convener of the meeting, welcoming the members present, we invited all members present in the meeting to get themselves introduced to the house for fruitful discussions. After giving a brief account of the objective, he wanted to know from the circle officer of Jorhat East and West Revenue Circles the number of such irregular railway level crossings in their respective jurisdiction. Shri Such and Such, Jorhat West, and Shri Samiran Bora, Circle Officer Jorhat East, gave detailed account on such level crossing in their jurisdiction. Shri Such and Such invited Such and Such NF Railway Tinsukia to put forward his views from perspective of the NF Railway. Shri S. Hajam pointed out that railway has the right of ways over their track, and the NF Railway has certain safety and security standard to be followed while plying traffic in various routes. As such, illegal railway crossing.
Let them file their.
Lordship, on the last occasion, they have made a prayer for filing an affidavit in opposition, but in terms of the office note dated 17/5/2024, till date, they have not filed any affidavit, my lord. And my lord, one more thing, on the last occasion, my prayer for interim order was not entertained, my
What
lord.
interim orders do you want?
Lordship, it is required because after
What
the
interim order?
because, my lord, this unmanned level crossing is need to be manned level crossing in terms of the guidelines passed by the railway board, lordship, which I have annexed at page 152, annexure 29.
That's your prayer, final
That-
prayer.
Yes, but lordship, if they close this gate, my lord, it will lead to untold suffering, my lord.
What untold suffering?
Because, my lord, the petitioner and the people's.
Railway is to decide where a level crossing is to be established. You
But
cannot
lordship-
decide that it has to be
Your
near
lordship
your
is
land.
correct, but lordship may kindly come to another application which I have annexed, another letter, lordship. It is annexed.
What is it that you have presented here, Mr. Gupta?
My lord, this is the instructions, my lord, I have received.
You put it on record,
My lord,
file it.
no, there is already a manned railway crossing, my lord, near to the this business establishment.
File it.
My lord.
Lordship,
And
for
my
a
our
sake of
submission-
convenience, lordship, kindly Paris page number 155, lordship.
an illegal.
It is a
trespassing.
letter issued by them, Lordship, to the Deputy Commissioner. 155, Lordship.
Yes.
Lordship, in this letter, they have categorically mentioned that in terms of the above subject and reference, it is to kindly inform that the above mentioned location kilometer such and such between Sinamara, Mariani station is an unauthorized railway track crossing. As per Indian Railway Act, trespassing of railway property is a punishable offence. My lord, now come to para second. Moreover, as per new guidelines of Railway Board, new level crossings are not permitted and existing level crossing gates are required to be closed by providing road, overbridge, road, underbridge, merging and direct closure. There is an operation level crossing gate number Itna at a railway, which is only 1 kilometer away from the above location of unauthorized crossing. It has already been surveyed jointly and found that this crossing can be merged by providing road connection. However, the land where road is to be constructed for merger lies under state government. Therefore, to sort out the issue, road may please be constructed at the cost of state government and thus merging the above location with the operation level crossing gate. So they are not denying that this gate cannot be merged, my lord. Since there is already one gate is there, my lord, that the man level crossing gate number 77. So this can be also merged with that gate, my lord, as per this letter.
Basically, my lord, what they are.
And they are also agreeing in this contention, my lord, in terms of this letter, my lord. So I'm relying on this letter so that, my lord, the unmanned level crossing gate can be merged with the man level crossing gate.
That's right. There's a procedure. But
Yes.
what interim orders do you want?
Lordship,
We can't
because,
give you interim orders.
because they are issuing notice day by day, while recently
They
they have
want to
issued.
continue to illegally trespass
You
to that
can't
track.
use that. It is.
You cannot.
There
it
is
is
no other
unauthorized.
alternate road, my lord. No
There is a
motor-
alternative road, my lord. I have
my
given
lord.
the instruction.
It
There
is
is a
not a
alternative.
motorable road,
It is
my
only
lord.
one business establishment, my lord, which
Let him
wants.
file the affidavit, you respond to it. Let him file the affidavit.
No coercive action may be taken,
Where is
my
the-
lord, because they have issued another letter, my lord. I may be allowed to file this notice, my lord, in
You bring it on record.
till then, my lord, no coercive
But
action.
you can't use an unauthorized
Railway track, how can they
unmanned
use?
crossing because it is convenient to you.
Lordship is
You can't
correct,
do
but
that.
my lordship,
We can't give you orders to permit you to do that. If you are doing it, you are doing it at your own risk and risk.
Accidents have taken place, my
Lordship.
lord. I have given in my instruction.
We can't permit you to do that. You have developed a crossing because it suits you and you want to use
Yes.
that crossing. And you
Lordship,
want
duty is cast upon the railways to
exactly they
convert this
no,
unmanned
no,
level
that's
crossing.
right. But they say that no longer new crossings are there, other road overbridge or underbridge has to be constructed.
Yes, lordship.
So that will take its own time.
No, lordship, but as per the budget, railway budget 2009-10, they have made a commitment to the railway ministry that, my lord, out of
Go and
70,000.
file applications before the railway ministry too.
Lordship, I have already produced this letter on record, lordship.
You bring it on record.
It is there, lordship.
No, that some notice you wanted to bring it on record, you bring it on record.
All right.
Then the counsel to the petitioner is permitted to bring on record. The notice received during the pendency of the writ petition by way of additional affidavit. Railway Council, Mr. Gupta, also submits that he has received instructions and he'd like to file a necessary. It's allowed. They start 3 weeks. Anyone else appearing? M. Das from PW.
Be done.
Till date, my lord, if lordship permit kindly, the railway cannot take any coercive action because
What
of,
coercive action? Closure.
yes, lordship.
They will do it as per rules. As per rules.
But
How
this
can
is
you
the
keep-
only way to ingress or egress the complex, my lord, and more than 700 to 800
File a
people are
proper, you file a proper proceeding before an appropriate forum. For an appropriate forum, this is a matter of evidence. You file an appropriate proceeding before an appropriate forum. That this, because of the inaction of the railways or lack of action on part of the railways, your ingress and egress is restricted. You file, get order. But as a writ court, how can we pass an order merely on your submission?
some
What evidence have you
directions,
led?
lordship, some directions in the nature of mandamus, lordship, will be very much.
You establish your right, that this is your right to have this access through the railways, railway crossing. You establish your right.
But they have also agreed that there can be merger, my lord. In
Exactly,
between.
let them merge. If you want, we can issue a direction and close it right away. that they will proceed on these terms of the communication and liaison with the state to merge. That's all we can do.
That aspect may kindly be reflected in the order, Lordship allows. that.
Why?
Because as per that,
Tendency of the writ petition shall not be a bar for the railways to merge the unmanned.
For that,
crossing.
my lord, I have to take instruction, my lord. I cannot submit. because
There is
the
a letter,
Policy decision, my lord.
that's a letter. You have referred. Merge the unmanned railway crossing with the railway crossing in terms of their letter. Where is that page number?
page number, Lordship. Page number 150,
In terms of the letter,
31st January 2023.
One fifty, my lord,
150.
is not our letter, my lord. It is the deputy commissioner.
Sorry, 155, my lord. 155.
in terms of the letter dated 22/5/2023 issued by the divisional engineer and Railway, the deputy commissioner Jorat. Yes.
Highly obliged.
May I please, Your Lordship? Your Lordship, as per the last order, Your Lordship, we have made a prayer for implement of the Jal Shakti, Your Lordship, as a necessary party in this petition, Your Lordship. Therefore, this interlocutory application has been listed before this honorable court, Your Lordship.
In terms of the earlier order dated 27/3/2024 passed in WPC 2246 of 2023, liberty was granted to the petitioner to file an application for implement of the Ministry of Jal Shakti, Government of Assam. In pursuance to this liberty granted by the court, the present application IA has been filed seeking implement of Ministry of Jal Shakti, Government of India as a party respondent in WPC number 20. Anyone for the respondent? Yes.
Yes, Lordship, and for the all the respondents.
You are for all the respondents. Any
One to
objection?
four.
Any objection?
No, Lordship.
MS so learned counsel appearing for all the respondents or of the party has been served with a copy and she does not raise any objections to prayer mail accordingly. The I is allowed. Ministry of Jal Shakti, Government of India. Department of Water Resources, Rural Development, Ganga Rejuvenation. Spencer Road, New Delhi. Is the raid as party respondent number 5 in WPC 2246 of 2023. This will be in IA. IA is accordingly allowed and disposed of. The writ petition, right, in terms of the view of the order passed in IA number so and so. In view of the order passed today, IA number so and so, Ministry of Jal Shakti so and so is the raid as party respondent 5. The petitioner is to file amended post title before the registry within 2 weeks from today. And the registry is to make necessary endorsement if so required. Meanwhile, let notice be issued on the respondent, newly impleted respondent number 5. Anyone is accepting notice on Union of India? Anybody there? CGC? Mr. T. Goy, learned counsel appearing, learned CGC, appears and accepts notice on behalf of the newly implemented respondent number 5. Since notices are issued, since the CGC appears, notices are waived, extra copies be furnished within a period of 1 week from the date. Mr. Gugoi may complete his instructions and is permitted to file necessary counter if so indicates. Matter be listed after 3 weeks.
Yes, Your Lordship.
minutes for order 748.
None appears for the petitioner on all matter passed over. With me.
May I please, your lordship? Lordship, 1 week time may be granted your lordship to take press steps, your lordship.
Counsel to the petitioner prays for a week's time to take fresh steps on service of respondent. Prayer makes the allowed. It's stop.
Against my lordship.
Item 61.
Lordship, I have received instruction to appear as soon about key lordship. As per the instruction, lordship, the amount was already disbursed, lordship. Petitioner received the check from the concerned bank on 24/2024, lordship.
Order complied.
Lordship.
Yes.
May I please, your lordship? Respondent number 3 has issued a check, 7,51,214, but he has asked the petitioner not to deposit the check for 2 weeks, lordship.
What is it?
She can deposit, lordship. She can deposit, lordship.
They have, it's all.
Yes, because lordship, there is a video was transferred, all instruction is here, even photographs also here.
You deposit and come back next week. You deposit the check.
Lordship, even photographs also there, or receive the check, lordship.
No, she has not denied. She said that don't deposit.
She can, lordship.
What
No,
is the
no,
use of issuing a check?
no, even lordship, the bank was operated by the lordship, Madam Klein, lordship. They also, there is no issue.
Deposited the check, lordship.
There is no issue regarding
Go
fund,
for
lordship.
counsel appearing for respondent number.
3, lordship. 3.
There is no 3.
I'm for 3, lordship.
I'm appearing for 1 and 2.
Contempt petition number.
65 of 24.
Oh, sorry.
65 of
You're on the wrong. 65.
Yes.
Google appears for respondent number
3, lordship.
Who submits that the check amounting to rupees
7,51,214.
751,214
Yes, sir.
has been issued to the writ petitioner. Stop. The counsel appearing for the petitioner submits that the petitioner has received the check, but has not yet deposited the same. But she does not have instructions whether the check has been deposited. The bank has. Ms. Moral and counsel appearing for
1 and 2, lord.
1 and 2. Appears for 1 and 2. Let the matter be listed after 2 weeks.
Yes, sir. After
Meanwhile, you deposit and confirm.
Because it takes some time, lordship.
2 weeks. Good enough. Matter be listed after.
Item 53.
This is amendment petition, my lord. Amendment of this. Final pending.
Amendment of the writ petition.
Writ petition, my lord. Annexures are there, that is bulky, my lord.
You are praying for an amendment or amended writ petition?
No, amendment, praying for amendment.
Praying for amendment. Then we will let us issue any objections.
Actually, principally, I have no objection, but in garb of amendment, many new thing has been tried to incorporate.
But we are asking you.
Otherwise, lordship, everything is settled. Lordship, may allow the amendment, we'll file our objection.
We shall file consultation with petition, my lord.
Mr. G. N. Sahiwala, learned senior counsel, assisted by Mr.
H.K. Sharma.
H.K. Sharma, appears for the applicant, writ petitioner. Stop the present application. IA has been filed seeking amendment of the writ petition. Stop. Mr. SCAR, the council, council appearing for
GST.
for the GST, central government GST. Submits that he does not object to the amendments or to be made. However, liberty be granted to the respondents to file their counter affidavit in response to the amendments incorporated in the amended petition. Review the submissions made, I stands allowed. Writ petitioner is permitted to file the amended writ petition within a period of 4 weeks from today. So the writ petitioner will file the amended writ petition and serve copies thereof to the standing council, CGST. The standing council will thereafter be at liberty to file their counter affidavit within a further period of 2 weeks.
4 weeks.
4 weeks.
We shall file it in 2 weeks.
Matter being listed, so and so, IA accordingly is allowed. Dispose of.
Item 54.
Lord, in this case, the auctions of the two tea gardens, 54 and 55 are connected to tea estates by the PF authority. Those were challenged. However, the auctions have now failed due to lack of bidders.
Failed. Okay.
Lord, perhaps nothing. Lordship may close these two writ petitions with the only one direction we will pray for, that the PF may inform us prior to the next auction, if any.
That doesn't require
You are appearing for?
for the PF, respondent number 4 and respondent number 6. We issued the e-auction notice. Lordship, whenever we do an e-auction, it will be public
Public
notice.
is a separate thing. Let us, as a co-creditor, at least that
Lordship,
much.
direction is not required. We will inform you.
Auction, what was the auction for?
Of the entire it's for recovery of the PF dues. And we are the secured creditor in respect to
Tea
the mortgage.
estates under the ATC.
Yes, your lordship.
My learned friend is appearing for the ATC.
And you have not deposited the PF demand.
Yes,
PF
by
amount.
the
lessee.
By the lessee, madam.
By the lessee.
Lessee, yes.
Lessee is number 7.
Yes, ma'am.
Yes, sir.
It is submitted by Mr. Ganguly that the e-auction sale notice dated 8/3/2024 issued by the recovery officer, Assam Tea Employees Provident Fund Organization for sale of Rajabari Tea Estate has failed in view of the lack of bidders. So he submits that in view of the fact that the auction in response to the e-auction, since there were no bidders, the PF authority cannot proceed with the auction according to press auction, if so advised, may be required to initiate that view of the matter, that further needs to be decided with the boy
I pay for respondent number 2. ATC.
accordingly with the accordingly instead. Close.
Close.
Close the
It's infractuous, actually. Lordship,
MS has IPS for respondent.
No,
So
the-
there is petition.
No, the PF will may inform us before any, that may
The
be.
e-auction, yes.
yes, you will be informed. We will inform you. Direct.
That is recorded, no difficulty. Suppose, because we have to again perhaps enter to your lordship.
By the council for the petition that hasn't had the next auction. It's right. Yep. For military major.
Lordship, you should not become a precedent because Every time then we'll have to separately inform a secure creditor. That is our problem. It's an e-auction, everybody gets to know.
We'll say that to the prayer made by the counsel for the petitioner seeking prior intimation.
Counsel for respond number assured.
No, counsel for the petitioner seeking prior intimation in respect of the fresh auction notice that may be defined from our counsel for the EF department.
Assures
that the department will notify the bank as it mentioned any.
Right. One is Rajabari, the other is Deepling.
Yes.
Same thing.
Next item, same.
Next item.
Other is
Deepling.
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 Five to down. 54. 55.
Telling to yes, the Deepling.
1874 is Deepling.
Deepling. DWPLI. Yes, it's both.
Right.
Problem.
Yes, what have you found?
Nothing is there about this case.
Nothing.
What?
Heard learned counsel for the parties in pursuance to the order dated 3/5/2024. Earlier, this court by order dated 3/5/2024 directed the officer in charge to produce the original record general diary of the Toboka police station from 1/5/2022 to 31/8/2022 and from 1/2/2024 to 30/04/2024. Stop. The officer in charge was directed to ensure that the police personnel from his police station produces the original general diary of the police station for the aforementioned dates on 20/05/2024 at 10:15 a.m. Today, when the matter is called on board, the counsel for the government counsel informed the court that the officer, along with the records, is on his way. He was stopped. The court noticed that the officer is not available before this court, as directed earlier, at 10:15 a.m. So, however, considering the submission of the learned government advocate, that he's on his way along with the records, the court deferred the matter for a while to be called up later in the day. So, subsequently, when the matter was called up again, and the government officer and the government advocate, upon receipt of the general diary concern, upon careful let's inform the court that there is no reference or there is no reference or registration with respect to the complaints raised by the stated to have been filed by the writ petition. Stop. The record of the grievance of the writ petitioner The government advocate, the basis of the reports for not produced before the court, any entry in the journal diary in respect of the complaint stated to have been filed, by the under certain circumstances. On the other hand, copy of the instructions the government advocate by the ST by the communication dated 5/24 is also available in the case report. As per the state communication, the SP Ujai has informed the government advocate that as per available Topoka case report, SI Sofikul Islam completed the inquiry report. He then, officer in charge, Topoka case. And after preliminary inquiry report, it was revealed that there was a minor scuffle between the complaint and the accused parties, but no person found injured, and there was no such evidence of wrong confinement of the petition. Also, the inquiry officer was also informed that the petitioner, inquiry officer also informed the petitioner to approach magistrate since the case was a non-cognizant offense. On the other end, both the parties also stated that they could compromise the case. Better. In the absence of any records available for SC from the original general diary reports as produced into the court, let the SP Ojai file an affidavit in court and enclosing the preliminary inquiry report stated to have been conducted and submitted by SI Sofikul Islam, the then officer in charge of the Topoka state. So, but before he conducts an inquiry, there has to be an entry here.
Lordship has rightly directed the SP. Let him come up with the inquiry report. How it was initiated? Initiation has to be there.
Will also state in his affidavit as to how the inquiry was initiated by the concerned SI, namely Sofikul Islam. In other words, what steps were followed prior to initiating the inquiry and submitting the inquiry. Let this affidavit be filed within a period of 2 weeks. So, reports were examined by the court as well as by the government officer, and in the presence of senior government appearing for the government. Accordingly, the same are returned back to the government advocate to be sent back to the station. So, let this affidavit be filed within a period of 2 weeks. List according